Mr. Jones, we're just waiting on Mr. Penny to sign in, okay?
Yeah, I'll try and get a hold of him because we agreed to meet at 8:30 and he's usually incredibly reliable.
Yeah, no problem. Calling parties on Tillman. Case number 2159652. The people of the state of Michigan versus Correll Tillman. The defendant is charged with count 1, assault with a dangerous weapon, assault, count 2, weapons, felony firearms, second offense notice, count 3, weapons, firearms, possession by felon, count 4, weapons, felony firearms, second offense notice, habitual offender, fourth offense notice. The defendant is also charged in case number 2159653. The people of the state of versus Correll Thomas Tillman. Defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, domestic violence, habitual offender, fourth offense notice. These matters are scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Jacob Bloomers, P77307 on behalf of the people.
Good morning, Your Honor. Neighborhood Defender Service by Natalie Phelps, P number 83355, appearing on behalf of Mr. Tillman, who is also present via Zoom. Mr. Tillman, can you please state your name for the record?
My name is Correll Tillman.
Thank you. What's your pleasure?
Your Honor, we would like to set this matter for an in-person preliminary examination as soon as possible. This is a domestic violence case and there is a no contact order and a tether imposed right now. And I have also not received any discovery, paper or digital, so I'd also request a discovery order. If you would sign that, please, I would email that to you now.
You can certainly forward that on to me. Mr. Bloomers, as to discovery.
Paper discovery in both matters was sent to Renee Wilson, which is the discovery person yesterday. So I will just send it directly to Phelps today. As far as digital, the GBH case was a walk-in, so I don't think there's going to be, well, it says there's body cam. I'll have to look. I definitely do have video in the other case, which I will get to Ms. Phelps.
Okay.
And then I'll follow up on the GBH.
Are there any concerns regarding the bond that would affect the timing of this exam, Mr.
No, Judge. There is, as defense stated, there is a GPS tether in place. The bond on the felonious assault file is $15,000, 10% with the GPS. And I'm sorry, I don't have the other one in front of me, but I think that one will make it sufficient as far as the people are concerned. But let me check real quick.
Mr. Bloomers, your audio is kind of breaking up and Madam Court Reporter can't record what you're saying. Also, Mr. Tillman, can you give me video? Good morning, Mr. Gopa.
View?
Video, yes, I can't see your face.
Okay, trying to, right here.
There you go. So Mr. Bloomers, we got the gist of what you were saying, but Madam Court Reporter can't record because your audio was going in and out. So if you could just kindly repeat what you said, that'd be great.
Okay, I hope it goes better this time. In short, the defendant is on tether. There was some cash with a 10% both files, so the people are satisfied.
Some cash. Wait, what did you say?
Cash with the 10% provision on both files.
Thank you. Okay, so with that being said, Madam Clerk, what can we do? And maybe I think the earliest we can do would be October. Obviously, if you're in my court often, you know we're actually in December with dates, but with domestic violence allegations, I like to bring them closer.
October 13th at 11:30.
Your Honor, that works for me. I do believe that Mr. Tillman shares children in common with the alleged victim in this case. So I would ask, I'm not totally sure what the bond conditions are. We only just spoke for the first time this morning, but I would just ask that indirect contact be allowed so that just for the purposes of child custody issues.
So, Mr. Bloomers, is there any objection to amending to no assaultive contact?
Well, no, I mean, I would still object to any direct contact. I would not object to third-party contact involving childcare issues. I haven't had a complaining witness, but I'm going to object to direct contact.
Your audio, we're getting like every third word.
Okay. I don't know what I'm just going to have to walk over the court after this one because I don't know what's causing that.
Okay, so if you, Madam Defense, if you could prepare a proposed order to that effect, that would probably be the most efficient way that we can process this, indicating the proposed order should indicate the alteration from a no contact order, not directly or indirectly, amending from that to third party contact is permissible.
Okay, we'll bring him over.
For the purposes of satisfying family obligations. So if you could send a proposed order to not only myself, but Mr. Bloomers, and if it's in order, I will sign it and forward it back.
Great, thank you, Your Honor. And we said 11:30 on 10/13.
Yes, ma'am, for both files.
Great, thank you so much. Have a great weekend, everyone. Mr. Tillman, you're all good to leave the meeting, and I'll give you a call, okay?
Okay, thank you.
Mr. Schulman, do you need a breakout room with Mr. Walker?
Are you speaking to me?
No,
Oh, okay, thank you.
Mr. Schulman. Calling parties on Laughlin. Case number 2062406, the people of the state of Michigan versus DeAndre Matthew Laughlin. The defendant is charged with count 1, larceny by conversion, $20,000 or more, habitual offender, third offense notice. Judge, this is actually scheduled for an exam on August 12th, but they're entering into a video today.
Oh, okay, great, thank you. Appearances, please.
Good morning, Your Honor. Matthew Penny, P74079 for the people.
Good morning.
Good morning to you, Judge, your incredible staff, most notably Tammy Jones, and brother counsel. My name is Jonathan Jones. I appear on behalf and with Mr. Laughlin, and we're very happy that you let us add on to the docket. And I'm going to let my esteemed colleague explain to you exactly what we're doing.
Thank you.
Judge, we're here brought in early. We've reached a resolution in Mr. Laughlin's two matters here. Mr. Laughlin will plead guilty as charged in both cases. The case that is the 2020 case that ends in, I guess, 06. We will stipulate to restitution in that case for $25,678.93. I have forwarded the plea forms to the court, so hopefully the court can kind of follow along with me as we're going here. He will plead guilty as charged in this case, his companion case, and also a pending Allen Park receiving and concealing stolen motor vehicle case. That case does not have a Allen Park case number yet. We will agree to 3 years of probation, and then on the date of sentencing, he needs to make a good faith payment toward his global restitution. For the record, the restitution on the 2021 case that ends in 8-1 is going to be $24,163.21, same terms and conditions. Is that a fair statement, Mr. Jones?
I think it's completely accurate, Mr. Penny.
Thank you very much, Mr. Jones.
Okay, so he's going to be pleading on both of these files before me, and he's going to be pleading to the same count 1 amending to count 1 larceny by conversion, the misdemeanor. Oh, I'm sorry. No. Is he waiving today? What are you doing today?
Yeah, I thank you, Judge. We were set for exam, but based on the resolution we've come up with, I guess technically he needs to waive the exam in order to do that. I also want the record to reflect, he does understand that the case will then go to Frank Murphy, and whomever would have been the arraigning judge will become the sentencing judge. I want the record to be clean on that because he has a right to be sentenced by the judge who took the plea, and we're going into this knowing that that will not be you.
Okay, so Mr. Laughlin, can you please state your name, sir?
DeAndre Matthew Laughlin.
Thank you. Okay, so again, this is going to be a waiver with regards to this, with the idea in mind that this is the negotiation that he'll be allowed to take advantage of once it's been bound over, correct?
You can actually take the plea here today if the
No,
court.
I don't want to. I don't want to take the plea if it's going across the street.
Oh, well, I didn't know that. I mean, if you can keep it and sentence it, whatever's easier and more efficient. Judge.
I cannot sentence on a felony, so what is more efficient is for the waiver to occur and for him to take advantage across the street. That is the cleanest way from our vantage point, as opposed to me accepting a plea on a felony and him being sentenced across the street. So if you want to talk, if that's not ideal, if that's not what you anticipated, let's circle back. We'll pass on it if you'd like.
It's okay. What we're going to do is Matthew, I asked you to place on the record that the deal will be good across the street at the AOI.
And that's okay. It will.
Judge,
we can hold
having
that
said
open.
that, thank you for the clarification. He understands his right to a preliminary exam on all the charges. At such exam, the people would have to demonstrate by a probable cause standard that he committed the crime as well as crimes were committed. Without objection from the people, if we waive that exam, the case will then be bound over to Wayne County Circuit Court for any and all future proceedings.
Okay, sir, do you understand the allegations against you, first of all?
Yes.
And do you understand that there's this negotiation that's on the floor here that's been articulated on the record?
Yes.
Do you have any questions about the negotiation as it's been articulated on the record?
No, ma'am.
Pardon?
No, ma'am.
Okay, so with that in mind, the understanding is that you would be waiving your examination as to both of these matters. That would be 200622406 as well as 210555781, with the idea in mind that once this matter is brought forward in circuit court, you would be permitted to take advantage of this negotiation that has been laid out. You understand that?
Yes.
Okay, so with that being said, do you understand that you do have a right to a preliminary examination on these two files?
Yes.
And do you understand that if an examination did occur, that prosecutor would need to establish by a probable cause standard only that crimes were committed in the city of Detroit, County of Wayne, and that you probably committed those crimes?
Yes.
And if the prosecutor was able to meet that burden, the matter would then be bound over to circuit court for further proceedings. Do you understand that process? I need an audible answer.
Speak up.
Yes.
Okay, and the representation that's been made is that you're waiving your right to preliminary examination. Do you understand that that means that this matter would automatically be bound over to the circuit court for further proceedings, i.e. the negotiation, without the benefit of an exam at this phase? Do you understand that?
Yes.
And is that what you wish to do, sir?
Yes.
And are you doing so voluntarily?
Yes.
Thank you. And there's one more thing I remember hearing the prosecutor say, and I just want to make sure that you understand that aspect as well, that there is an Allen Park case that, Mr. Prosecutor, you're expecting a plea on that as well?
That's correct, Your Honor.
Okay, you understand that, Mr. Laughlin?
Yes.
Okay, all right. With that being said, I do find your waiver to be knowingly and voluntarily given. Both files are going to be bound over to the circuit court, wherein you will certainly be permitted to take advantage of this negotiation that's been laid out. I will need, if the examination waiver forms have not been filled out, I will need those to be filled out.
I'll have to email it to the judge.
Okay, they'll be forwarded to you shortly by Madam Clerk, and we'll need those back. In order to process the waivers, we will need those back this morning. So please, once you receive it, please make sure that you return it back. And the arraignment on information date is going to be August 20th. Is there anything further?
Is it just a regular night? You don't know which docket or who the judge is, just it's that morning on the 20th?
Yes.
Okay, awesome. Yep, as soon as we get the forms, we'll sign them and turn them back to you, Judge. Thanks a ton. Stay safe. Have a great weekend.
You too. Thank you.
Mr. Jones, could I get your email just to make sure I have it?
Yes, it's all lowercase, JJONESCRIMLAW@comcast.net.
And Tammy, I'll
Thank you.
forward that email address to you as well, okay?
Thank you, I appreciate it.
Thank you.
Stay
Thank you
safe,
very much,
everybody.
Judge. Apologize for the lateness. I apologize for that.
Oh, you're fine.
Thanks. Have a nice day, everybody.
You.
Mr. Schulman, did you need a break room with Mr. Walker?
Well, we were just gonna set it for an exam. I just got the discovery and I was gonna go visit him. That was the plan.
Okay, so you don't need a breakout room?
No.
Okay. Calling parties on Walker. Case number 2159570. The people of the state of Michigan versus Dominic Jante Walker. The defendant is charged with count 1, stolen property, receiving and concealing $20,000 or more. Count 2, police officer fleeing third-degree vehicle code. Count 3, police officer assaulting, resisting, obstructing. Habitual offender, second offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Slufsky on behalf of the people, P83677.
And good morning, Your Honor. Sanford Schulman, P43230, appearing on behalf of Dominic Jante Walker, who's appearing from the Wayne County Jail. Today's the PCC, probable cause conference. He's appearing by way of video conferencing. I just received the discovery and I was planning to see him today. If the court is not inclined to set it for another PCC, we'd ask to set it down for an exam.
Okay, well, I'm sorry, please forgive me, I was writing on the last file. Is your client here?
I have not yet met him. I assume he has a federal hold on him, is what I understand. So
If you're, please state your name.
Dominique Walker.
he's participating by video conferencing, Your Honor.
Oh, yes, thank you. So for anyone, when the cases are called, please know, I have an expectation of a couple of things, and I should have said this at the onset. For those of you that are not familiar with Zoom court, please make sure that you are clothed, that you're wearing clothes in the Zoom court, that you're not doing anything that would be inappropriate inside of an actual courtroom, that you refrain from the use of any profanity or any outbursts, and that you simply conduct yourself as you would if you were inside of the courtroom. That's something I intend to say at the beginning of every morning, and inevitably we always get people who are not wearing clothes that appear in Zoom court. So please make sure, that's a big one for me. Also, when the cases are called, please allow to the attorneys, please allow the prosecutor to go first. We don't have a prosecutor, it's nothing personal, but we will have to pass on your matter. Defense counsel would go next, and then before we get into anything substantive, I do need the defendant themselves to put their name on the record. Now, please don't assume I know whether your client is there, whether your client is in or out. I don't know. So please make sure if your client is not present that you are asking for their presence to be waived. And then that will be the launching pad for every single matter that's called here today. Now that we have Mr. Walker's appearance on the record, you're asking for another PCC or an exam date. We certainly can accommodate your client being in custody. We will make sure he gets an exam date in 7 days if you'd like.
Your Honor, I would rather have one last PCC only because I just got the discovery and I was going to go see him, and I don't want to, use unnecessary resources to produce witnesses. It's likely that we will be demanding an exam, but some courts set it for an exam, and then sometimes there's waivers. But at a final PCC, as I'll call it, if there's going to be a waiver, I think that might be more economical. But I'm asking for one final PCC, or if that's not something the court is going to consider, then set it for an exam.
No, I'm fine with, if that's your request so that you can review the discovery and make an intelligent decision. I certainly find good cause to grant that request for an adjournment. The new PCC would be, I'm assuming you want a short adjournment, so
Yes.
Friday
the
6th is good for you.
It is. That's fine. And I will confer with him, and we'll be ready to apprise the court of whether it'll be a hold or a waiver.
Okay, perfect. So the new PCC is August 6th at 8:30 via Zoom. And is there anything further you wish to address, Mr.
Not
Schulman?
at this time, Your Honor.
Happy
Prosecution? Thank you.
Thank you.
Thanks, everybody.
It's Mr. There he is. Calling parties on Brown, Jamar Brown. Case number 2158231. The people of the state of Michigan versus Jamar Richard Brown. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons carrying concealed. Count 3 and 4, weapons, felony firearm. Count 5, police officer assaulting, resisting, obstructing. Habitual offender, fourth offense notice. Judge, this is up to date for a bond motion hearing.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Morning, Your Honor. Andrew Moxie, P number 69568, on behalf of Mr. Brown.
Mr. Brown?
Yes, Jamar Brown.
Thank you. It's a pleasure.
Judge, Mr. Brown is currently on a tether, home confinement. He has a doctor's surgery appointment on Monday to replace a metal part in his arm due to a gunshot in the past. So I'm asking his bond and tether confinement be modified to allow him to attend all doctor and hospital surgery appointments.
Any objection?
People stipulate.
I'm sorry.
People stipulate
Oh,
that.
you're okay, so Mr. Moxie, can I trouble you to prepare a proposed order to that effect and forward it to the court this morning?
Yes, Judge.
Indicating just that the alteration is going to allow your client to attend any medical appointments that he has, or otherwise medical, unless they're all medical appointments. Whose background noise is that? So I have no problem with muting people from time to time, but if there's a continual problem, I am going to just start removing people from the gallery. So if you could prepare a proposed order to the extent of what Mr. Prosecutor just stipulated to, that would be great. I'll go ahead and sign that and disseminate a copy back to both prosecution and defense.
Okay, thank you, Judge.
And you can forward it to Tammy Jones. Her email is at the top of the chat.
I got it. Okay.
Oh. Was there anything further you wish to address?
No, Judge.
Okay, we're all set then. Thank you so much.
Thank you.
Thank you.
You're welcome.
Wayne County Division 1, what's your name, sir?
D'Angelo Martin.
Thank you. Calling parties on day, case number 2159489. The people of the state of Michigan versus James Byron Day. The defendant is charged with count 1, home invasion, 3rd degree. Count 2, assault or assault and battery. Count 3, domestic violence. This is scheduled for a probable cause conference.
Thank you, ma'am. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Richard Banta on behalf of defendant James Day. I am not certain whether he's present or not, but if he is not present, I ask the court to waive his appearance.
Mr. Day? Okay, have you been in contact with him?
No, not yet. I just got this appointment recently.
I will waive his presence for purposes of today's proceeding. What's your pleasure?
We'd ask that it be set for a preliminary exam, Your Honor.
Okay, he is out on bond, correct?
As far as I know, yes, Your Honor.
I know his bond is at 50,000, 10% with the GPS tether. I don't know if he posted that or not.
Have you checked the system to see whether or not he is in custody?
No, I didn't have a chance to this morning, Your Honor.
Okay, I think we need to, because it's the difference between having an exam in 2 weeks or having an exam months from now.
All right,
We'll
what I'll
check.
do is I'll go to Sheriff Connect, see if I can find out whether he's in custody or not.
Perfect.
And then sign back on.
Perfect, thank you.
All right, thank you, Your Honor.
He wasn't on our list, but yeah, I don't think he posted bond. So I'll see if I can call the jail too.
Okay, perfect, thank you.
Mr. Bloomers, did all those motions or responses, was Martin in there from this morning?
Sorry, what my
You
thing?
sent me,
Yes, that was Martin.
Martin?
Everything was Martin.
was it all, oh, so I put
That was
it all
Martin
in,
plus attachments, yeah.
I put it all in the Maldonado file.
Oh, okay.
Can I see that real quick?
Yeah, no, so the other ones, like Maldonado's is bond, I think maybe on another bond. Martin was gonna take a few minutes. 'cause it's a little-
Okay, I just put it in the wrong
Yeah.
file. Okay, he's up, so I'm gonna call, let me see if I got a couple of things we can call real quick before we go to that. Oh, no, there's an interpreter here on Maldonado. Calling parties on Page, Douglas Page. Case number 2157004, the people of the state of Michigan versus Douglas MacArthur Page. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, domestic violence. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
And NDS by Lauren Anderson, P85191, on behalf of Mr. Page, who is present on Zoom.
Okay, Mr. Page, please state your name.
And he's the gentleman that I think was having some background noise. He may be having some technical issues. I know he was struggling to use Zoom earlier.
Are you requesting to waive his presence?
Yes, ma'am, if that would be possible, please.
Yes. Okay, what's your pleasure today?
Judge, I would request to set it for a preliminary examination.
Okay. Are there any concerns regarding bond, Mr. Prosecutor?
At this time, the bond is a 2,500, 10% with a no contact order. There is no tether in place. However, having had a chance to examine the file, the people are satisfied with the bond this time.
Okay. Can we have an October date? Please?
Yeah. October 12th at 9:30.
That's fine, Judge. Thank you.
Perfect. And for examination, October 12th at 9:30, please make sure that your client knows that he needs to be present inside of the courtroom, not in Zoom. And we'll see you then at 9:30.
Thank you. And Judge, I haven't received any paper or digital discovery. Mr. Bloomers may have sent it over yesterday and it just hasn't made it to us, but would Your Honor be willing to sign a discovery order?
Okay. Mr. Bloomers, can you get that discovery to me?
Yeah, and I will restate, yes, I did send it to NBS's Central Discovery yesterday, but I will just send it directly to Ms. Anderson when I get back to the office today.
Thank you so much.
Problems between now and October 12th? If you have any problems between now and the exam date, please make sure you notify the court and the prosecution, and we'll tee this up for a motion hearing, okay?
Thank you so much, Judge.
Bob will continue.
All right, Mr. Page, you can sign off. I'll call you.
Hopefully 2 other quick matters and then we go to this meeting. Calling parties on Epps. Case number 2157895, the people of the state of Michigan versus Suleiman Kamate Epps. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons, felony firearm. Count 3, weapons, carrying concealed. Habitual offender, fourth offense notice. Commission of a felony with a motor vehicle advisory. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Scott Nadeau, P64316, on behalf of Mr. Epps.
Thank you.
Yeah,
I did not hear the prosecutor's appearance.
Ms. Bailey?
We are obviously going to have to pass on. For anyone that is new to Zoom court, welcome. I do need you to keep your microphones muted, even if you're on the instant case. We're actually not proceeding on it because we don't have a prosecutor right now. So,
Well, I would ask for a preliminary exam anyway.
oh, okay, great. We still need a prosecutor. And I also want to make note that if you are the defendant in a matter, please make sure your video is also rolling when your case is called. And it would also be helpful if you named your device to your actual name as opposed to just iPhone. I've got two people who are listed as iPhone and not their name.
Yes. Okay, thank you.
Mr. Defense Counsel, I do understand what you're seeking. It's just I kind of need the other party here.
I understand. Perhaps there's a prosecutor to stand in for this purpose. I only said on to another Zoom call.
Have a prosecutor in the courtroom.
Oh, okay, here we go. Is this your case, Miss Bailey?
Which one? F's?
F, yes, that is mine.
Okay. It was just called. Can I have appearances?
Bryn Bailey on behalf of the people, P84009.
You want mine again? Scott Nadeau, P64316.
Thank you. And your name? Oh, sorry.
It's okay.
Your P number, sir?
P64316.
Thank you. Your client, could your client put their name on if they're here?
He is not here, and I would waive his presence for the purposes of this hearing, accepting all limitations of Zoom.
Okay. So ordered, and you indicated earlier off the record, you're asking for an in-person examination, correct?
Correct.
Madam? December, it's going to be in December sometime, so you know.
December?
We are in December. I'm assuming that most defense attorneys that, you know, practice in at least 36 district court are familiar and not, you know, shocked by where we are, and that you're likewise having a conversation with your respective clients, because I know if you're not familiar with the court system, or speaking to those that are appearing in Zoom gallery as defendants or witnesses, it can be a shock, because you may think, well, the court system has just been chugging along and hasn't been affected by the pandemic, but it's been quite the opposite. We've been affected like every other aspect of life. So it's important. If you have questions or concerns about that, please make sure you're talking to your attorney, because in the event that your matter passes beyond this phase, guess what? You're also looking at a tremendous backup across the street in circuit court. So that's always a good conversation to have with your respective clients, so they're not sandbagged thinking December, what is that? What are we talking about here? Unfortunately, we can only work so many hours in a day. So with that being said,
December 10th at 9:30.
Good. I was just, I'm familiar with 36 and how backed up it is, but that's the first December I've heard. I want to make sure.
Yeah.
We're already talking about
December.
2022, apparently.
December at 9:30 will be the in-person examination date, if that was good. And just as a side note, if I could digress, if your client was in custody, now that would be a different thing. We would squeeze you within the next 14 days. But we are spilling over at the brim, and I think people don't believe us. I guess you can always sit and watch us on YouTube and see what happens, but we're spilling at the brim in terms of what we're dealing with here. So it's an interesting process, but it's something, a crescendo effect, if you will, of the pandemic. So let me also say this, for anyone that counsel included on this matter and anyone else, if you want an earlier exam date, like within the next 14 days, on a non-custodial matter, I can give it to you. Here's the trick though. If you have a non-custodial, if it's in custody, we're gonna make it happen. If it's a non-custodial matter, I can give you an exam date as soon as you want, within 7 days if you want. as long as that's enough time to notice the complaining witness. The only caveat to that is that when you come, if I'm giving you that quick of an exam date on a matter where your client is not in custody, it's a roll of the dice. You may sit there all morning, only to be called in at 12:25 to be given a new date, which typically is the case. But I will always put that option out to the defense attorneys. I just, want to make sure that you understand what we're dealing with here. So would you like an exam within the next 2 weeks?
No, I'm fine. I'm fine with this, Judge.
Okay.
I just wanted to ask the
Always
question.
enough?
Is it going to be,
Yeah.
is the exam before you?
It is.
Okay, good.
Would you like it before a different judge? We can see if there's another judge that might take your exam.
No, sometimes they set these exams before a different judge, so I just want to make sure. Thank you.
No, it will stay here with me. Anything further?
Nothing.
For Mr. Nato's reference, I have some papers. I'm working on getting you any body worn camera, dash cam, anything extra like that. I was also wondering if you would be willing to potentially stipulate to a prior conviction of Mr. F.
I will. I've reviewed the police report. I'm assuming it is accurate, and I would stipulate such.
Thank
you.
Counsel, the only reason this case would deviate to another judge is if your client has another matter that's pending, another felony matter that's pending with a date of offense that is prior to this matter. If that's the case, and that comes to light, it would shift to a different judge. But otherwise, it's here with me.
Thank you.
Thank you.
Hopefully real quick. Calling parties on Bowles, BOLES. I see Mr. Calvin. Oh, there he is. Calling case number 2158886, the people of the state of Michigan versus Brandon Bowles. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons carried concealed. Count 3, weapons, felony firearm. Count 4, police officer assaulting, resisting, obstructing. Habitual offender, third offense notice. This is scheduled for a probable cause conference. Judge, we also had a case transferred down from Judge Jefferson. Case number 2159651. The people of the state of Michigan versus Brandon Bowles. The defendant is charged with count 1, police officer assaulting, resisting, obstructing. Habitual offender, third offense notice. These matters are scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Brent Bailey on behalf of the people, P84009.
Good morning, Your Honor. Evan Callahan, P30564, appearing on behalf of Mr. Bowles.
And your client? Your client?
No, that wasn't him. This is somebody else. They're in Zoom court right now for somebody else.
Your
They're
client
counting
said-
it.
Your client's name. Okay, let's pass on it. I'm not sure what's going on.
Calling parties on Martin. Case number 2061037. The people of the state of Michigan versus D'Angelo Devon Martin. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, assault with a dangerous weapon, felonious assault. Count 3, malicious destruction of personal property, $200 or more, but less than $1,000. Habitual offender, fourth offense notice. Judge, we're here today for a motion.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
What happened?
Mr. Riggins. No, we don't have Mr. Mr. Riggins?
Okay, we're gonna pass on this one as well.
That's the attention call.
Judge, what happened to my case?
Oh, I don't know. No one was responding to me. I was asking for your client to put their name on the record, and there was no response. I asked maybe 3 times. And
Okay.
you didn't, no one chimed in.
I would ask to waive his presence.
Oh, did you? Okay, you didn't hear me asking for his name, Mr. Callahan?
Well, you sort of broke up. I'm sorry.
Oh, okay. Well, this is the way working on Zoom. So if you aren't sure why your case gets passed on, please let me know. But as it relates to People versus Brandon Bowles on 210596510 21058888601. Appearances again, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. Evan Callahan, P30564 on behalf of Mr. Bowles in both cases.
Okay, and your client is in custody or out of custody?
I believe he's out of custody.
And you're requesting to waive his presence?
Yes.
Okay, so ordered. What's your pleasure?
I'm asking for an in-person exam.
Madam Clerk?
Judge, December 10th at 11 a.m.
On both cases.
11 and 11:30.
Thank you.
Which one at 11:30, Your Honor?
210588886 is going to be at 11 and the other one at 11:30.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
Judge, this is Attorney Bertram Johnson. I don't know if it matters, but I had a client, Algernon Moore, who's a co-defendant on a case with Brandon Bowles, who was just transferred over from Judge Jefferson, along with these other cases. So I don't know if that case was supposed to be called with this case or not.
I see.
Oh, I wasn't aware of that.
And I'll let
Judge.
him back in. He's in the waiting room. I'll wait until he gets connected to audio.
That's why I didn't know that.
Mhm. Mr. Moore, can you? Mr. Moore, can you hear us?
Judge, if there's a problem, he's been on all morning. I've been in communication with him. I can waive his presence because all we're asking for is a short adjournment.
Okay.
The PCC.
Well, I brought him back into the gallery. His device is there. I see his name. Can you hear us, Mr. Moore?
Yeah, yes, I can hear you now. I just came back in.
Okay, thank you. Could you please state your name?
Algernon Moore.
Thank you. Mr. Defense?
May it please the court, Bertram Johnson appearing on behalf of Algernon Moore, P46646. We waive, we consent to the Zoom conducting these proceedings with all its limitations.
Okay. Mr. Johnson, you said you were asking for another.
Yes, Judge, Judge, I'm asking for another short PCC. We did receive some discovery yesterday with the video. I'm assuming that we have it all. I just got this case. I will be speaking with Mr. Moore today. Just enough time to go through the discovery, deliver him the discovery, and make an intelligent decision on how he would like to proceed.
Okay. What do you want? Maybe 2 weeks or 4 weeks?
2 wees is fine, Judge.
All right. So the 13th, August 13th.
Judge,
That's
can I
fine.
suggest that we keep the cases together?
Sure. Well, I didn't really intend to split them. I think
Okay.
Mr. Johnson is expressing that he wants to review the discovery, and if I'm reading into it, I think he's trying to decide whether or not he wants to go to an exam. Certainly if he decides with his client that he wants to waive the exam, that would be an option that the court. And if he wants the exam, we would have the exam on the date that we set the other matter.
That is correct, Your Honor.
So if you
Okay.
want to join us for the PCC on August 13th, you can.
I'll join them for the PCC on August 13th.
Okay, but we're going to keep the exam date unless you want me to take that off the book.
No, I want you to keep that on.
Okay, gotcha. So for both individuals, Bowles and Moore, August 13th, PCC. Mr. Moore, please make sure you zoom in just as you did today at 8:30, same number. And we will go from there.
Thank you very much, Your Honor.
Thank you. Thanks for bringing that to our attention, Mr. Johnson.
Yes, thank you. Have a good weekend.
Oh, okay, thanks.
Mr. Riggins? Are the parties here on McCoy?
Just Ms. McCoy.
Just Ms. McCoy? Okay. All right, I don't have anything.
Madam Clerk, I have checked with regards to the defendant, James Day. It shows that his housing unit is the electronic monitoring unit. So I don't know if he's waiting for a tether or if he's got a tether and gotten out. No clue.
I believe that indicates he is on tether if his housing unit's been changed to electronic monitoring.
Okay, so let's recall People versus James Day, 210-59489. Appearances again, please.
Jacob Bloomers on behalf of People.
Morning, Your Honor. Richard Banta, P398455 for the defendant, James Day. I believe that Mr. Day may be out on tether, and if he is, I'd ask that the court waive his appearance.
So ordered. So you did in-person examination date, correct? And that's why we paused.
That's correct.
In or out. So with the understanding from your research, it sounds like he's out. So is there any concern regarding bond that might alter the timing?
No, Your Honor, the defendant is on a $50,000 10% bond with a GPS tether, and the people are satisfied.
Okay. Madam Clerk.
October 13th, 30,
At what time?
11:30.
That's fine. Thank you, Your Honor.
You're
Thank
welcome.
you, Madam Clerk. Have a nice weekend.
You too. Thank you. Be safe.
I need Mr. Riggins.
Your Honor,
Yes, ma'am.
Your Honor, this is Interpreter Villarreal, just notifying the court that I do have an in-person bench trial at 10:30.
Okay, thank you so much. We're gonna try and get you in and out of here before then, but thank you for letting us know.
Thank you.
Can we
Ms.
see?
Robinson is here, is she?
Someone else just popped up from the jail. Can we see who that is? What her client is?
Division.
Yeah, Your Honor. Excuse me. Yeah, I got
Brandon White Ratliff.
and then Mr. Maldonado, Rolando.
Okay, thank you.
Calling parties on White Ratliff. Case number 2159647, the people of the state of Michigan versus Brandon White Ratliff. The defendant is charged with count 1, domestic violence, third offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of People.
Good morning. If it may please the court, Sarah Robinson, P63181 for Mr. Brandon White Ratliff.
Okay, and your client?
He is present in the Wayne County Jail, Judge.
Please state your name.
Brandon White Ratliff.
Thank you. What's your pleasure, Ms. Robinson?
Judge, at this time, we'll be requesting an exam.
All right, would you like to select a date the week of August 16th?
And I just out of curiosity, Ms. Robinson, do you know why your client is in custody? Because he's bound as a $5,000 personal with the GPS.
He has a hold. He has a hold in another court.
Okay, that's, I was just curious. Thank you.
And I'm sorry, Judge, you said August 16th week?
Yes, please.
Is the 17th available for the court?
No, but we'll make it available for your client.
Or the 20th, whatever, the 17th or the 20th, Judge, is best for me, but whatever the court is best for the court.
Okay, thank you. Give us one moment.
The 20th at 11:30.
That's fine, thank you.
Okay, perfect. In-person examination, August 20th at 11:30.
Thank you. And Judge, I do not have the digital discovery. If Mr. Bloomers could send that to me. And also I'd like to submit an order, a discovery order for signature and entry.
Okay, thank you. Please forward that to Tammy Jones' email that's in the chat.
Thank you, Judge.
Thank you. Okay. This is going back to the prosecutor.
Yes, I'm sorry. Can I check in, please?
Mr. Sanders, your attorney, Mr. Winters, already appeared on your behalf. So you need to contact him. You have another probable cause date of September 3rd. So contact your attorney, Mr. Winters.
Okay, how about my brother Leon Sanders?
Okay, his attorney appeared for him too, Ms. Sanford, and he has the same court date, September 3rd. You both need to call your attorneys, okay?
Yes. Well, what time do they talk? We was too late. Should I get on at 8:30 or come on at 9 o'clock?
Sign right on at 8:30. Your case is scheduled at 8:30.
I'm sorry. I was late. I'm sorry. So there's no warrant for it. There's no warrant out for it, is it?
You're fine. Your next court date for both of you was September 3rd, but you both need to contact your attorneys.
Yes, ma'am. Thank you.
Okay, no problem. Have a good day.
You too. Yes. See here, September 3rd. Damn, 8:30. Damn. We put in at 8:30.
You're live, sir.
You hang this up. You'll be quiet.
All right. Now, these motions. We're gonna have to do Mr. Maldonado first. Because she has to go to. Yeah, but we need the interpreter on Mr. Maldonado. She says she's gotta leave at 10:30 something.
Oh. I think Mr. Riggins is on now.
Do what?
Is that Mr. Riggins there?
Yeah, he's up. We're gonna do Mr. Maldonado first though, because Madam Interpreter has to leave.
Yeah, that one I don't think will take very long.
Okay, okay. So we'll do that one first. Okay. Oh, okay.
For sure. Okay,
We're gonna call,
Mr. Riggins.
the case of
Hello.
the insurance first, though. I know
Okay.
Mr. Martin's been there longer, but she's gonna need to leave.
Okay.
Calling parties on Maldonado, case number 2159406. The people of the state of Michigan versus Rolando Maldonado. The defendant is charged with count 1, home invasion, first degree. Count 2 and 3, criminal sexual conduct, second degree during felony, SORA notice, HIV, STD testing notice. Count 4, criminal sexual conduct, fourth degree, force or coercion. SORA notice, HIV, STD testing notice. Count 5, criminal sexual conduct, fourth degree, force or coercion. SORA notice, HIV, STD testing notice. Count 6, domestic violence. Count 7, malicious destruction of personal property less than $200. Judge, this is scheduled for a motion hearing.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Neighborhood Defender Services by Ken Riggins, P82125, on behalf of Mr. Ronaldo Maldonado.
Thank you. Madam Interpreter?
Good morning, Your Honor. Interpreter Evelyn Villarreal, State Certified, here for Mr. Rolando Maldonado.
Thank you. Could you please raise your right hand? Do you solemnly swear or affirm to translate accurately and properly from English to Spanish, Spanish to English to the best of your ability?
Yes, I do, Your Honor.
Thank you. Could you please state your name, Mr. Maldonado?
Señor Maldonado, por favor, ¿puede usted decir su nombre?
Rolando Maldonado.
Rolando Maldonado.
Okay, counsel.
Bien, licenciado.
Thank you, Your Honor. If possible, I'd like to incorporate my previous argument for bond. Mr. Maldonado is employed. He is a highway construction worker.
Sí, buenos días, su señoría. Si es posible, me gustaría incluir los asuntos que previamente yo he mencionado con respecto a una fianza. El señor Maldonado tenía trabajo, trabaja por las autopistas.
He has worked in that position for 3 years since he's lived in the state of Michigan.
Ha trabajado en ese puesto por unos 3 años desde que ha estado viviendo en el estado de Michigan.
As far as his contact with his wife, Mr. Maldonado does have a separate address, separate from his wife, that he has the ability to stay at.
Y con respecto a él tener contacto con la esposa, el señor Maldonado tiene una dirección separada de su esposa. Él tiene una dirección separada donde él puede ir a vivir.
I'd also like to point out 2 other things. One, in reviewing the DSU report for Mr. Maldonado, he scored very low as far as his risk factors. Were it not for a statute, they even admit that he would probably be looking at a personal bond.
También quiero mencionar un par de cosas. Primeramente, me gustaría decir que según el reporte de DS1, él salió con un rango bien bajito para una indicación de si hay riesgo. Así que si no fuera por un estatuto, pudiéramos decir que él pudiera recibir una fianza personal de honor.
Also, and most importantly, I had an opportunity to speak to the victim, Mr. Maldonado's wife, the day before yesterday.
Y también quiero decir algo que es más importante. Yo hablé con la víctima, con la esposa del señor Maldonado. Hablé con ella el día antes de ayer.
She indicated that she wished him to get out so that he can assist her with the kids. I gave her Mr. Bloomer's number. I don't know if she reached out to him.
Ella me indicó a mí que ella le gustaría que él pudiera salir, ser liberado para que la pudiera ayudar a ella con los niños. Yo le di a ella el número del señor Bloomer para que se pudiera en contacto.
And so, Your Honor, we just asked for a personal bond so that Mr. Maldonado can get out and work and assist with his family.
Así que, su señoría, nosotros lo que estamos pidiendo es una fianza de honor para que el señor Maldonado pueda salir, pueda trabajar y que pueda ayudar a su familia.
Mr. Bloomers?
Your Honor, I would ask the judge, in keeping with the DS report, to take no action. I would point out one of the reasons that his score is so low is because they gave him -1 for being married, but of course, the victim is the person he's married to.
Su señoría, yo le pido a la Corte que continúe a seguir las recomendaciones del reporte de SU. Una de las razones por cuales le dieron crédito es debido a que tenía familia, pero es con la misma familia que tiene un problema. Y que le pedimos a la Corte que no tome acción ninguna.
I have not been able to speak with the complaining witness. And I would ask Mr. Riggins, my notes say that an interpreter would be needed. Did you speak to her with an interpreter or without?
Yo todavía no he hablado con la testigo denunciante y no sé si ella necesita intérprete. ¿Usted ya ha hablado con la testigo denunciante?
I spoke with her with Ms. Emma Hernandez.
Yo hablé con ella, con la señora Emma Hernández.
Okay. Well, at any rate, I think that there was no abuse of discretion in setting the bond where it is. The charges here are extremely serious. We're talking about a home invasion first degree leading to 4 counts of criminal sexual conduct, 2 of second degree and 2 of fourth degree.
Bueno, yo pienso aquí que deberíamos continuar, que no tomen alguna otra acción, debido a que los cargos aquí son muy serios. Estamos hablando de un cargo de invasión de hogar y estamos hablando de 4 cargos de conducta sexual criminal.
I certainly don't think a personal bond is appropriate given the nature of the charges.
Claro que debido al tipo de cargos con cuales se enfrenta, no creo que una fianza de honor sería apropiada.
So again, the people would object to any modification of bond at this time.
Así que repito, la Fiscalía se opone a que haya alguna modificación a la fianza que se le ha dado.
Notwithstanding the argument that's been made by Mr. Defense Counsel, I tend to agree with the prosecution as well as the DSU report that suggests there be no action. And what the court is considering is the assaultive nature of the offense, and the fact that the defendant does have recent ties out of state. If you look at the report, this is the benefit of having this DSU referral done, so that we can get an idea of what the background is of the defendant. Yes? Oh, did you want to translate that?
Yes, Your Honor, if I may. Bueno, he escuchado el argumento que ha hecho el abogado defensor, pero yo tengo que estar de acuerdo con el reporte preparado por el DSU y también con el comentario de la Fiscalía. No pienso que acción es debida en este momento. Tomo en cuenta el tipo de agresión en estas ofensas y tomo también en cuenta que él tiene enlaces afuera del Estado. Y esto es lo bueno de uno preparar un reporte por DS1, que así uno tiene una mejor idea del historial del individuo.
The motion to reduce the bond is denied. However, we can set this as early as 7 days from now, if you'd like.
Así que el pedimento, la moción para que la fianza quede modificada, queda denegada, pero podemos volver a reunirnos tan pronto como dentro de 7 días.
Yeah, as much as I would like to, due to Mr. Maldonado being incarcerated and me having to do our visit via Zoom with an interpreter, I don't think I'd be ready within 7 days. It takes almost 3 days just to get a hearing in for 30 minutes.
Su señoría, tal como a mí me gustaría tanto poder hacerlo dentro de 7 días, debido a que él está todavía en la cárcel, me parece que no estaría yo listo debido a que lo hacemos con un intérprete y por ahora se están tomando unos 3 días para fijar fechas.
And Your Honor, I'm sorry.
Is there a date you would like to select?
¿Tiene usted una fecha que le gustaría a usted escoger?
We have the 17th selected, Your Honor.
Hemos escogido el día 17, su señoría.
That's correct, Judge. August 17th at 11.
Okay.
Y eso es correcto, su señoría, el 17 de agosto a las 11 de la mañana.
Okay, I see Mr. Maldonado keeps raising his hand.
Así que le pedimos al señor Maldonado que levante la mano.
Is there something you would like to say, sir?
Usted levantó la mano. Dígame, señor, ¿hay algo que usted le gustaría decir?
Pues yo lo que quiero es que me dejen trabajar y yo sé que es mi primera vez y estoy bien arrepentido de lo que hice y ya no voy a ir a buscarla y que me den provecho y quiero trabajar, es lo único que quiero.
Well, the only thing that I would like to ask the court is to please let me work. This is the first time for me, and I really regret what I've done, and I'm not going to be going over to her. What I'd like is probation and to be able to work.
That is not decided here.
Eso no se decide aquí.
Again, I will go over that with you.
Y les repito, yo voy a revisar esto con ustedes. I'm sorry.
Okay, August 17th at 10 a.m.
Bien, así que el 17 de agosto a las 10 de la mañana.
For an in-person examination.
Y va a ser una audiencia en persona. Your Honor, may the interpreter, here again, I did not hear clearly, 11 a.m. or 10 a.m.?
I just want to
10
double check that there, did you say 10, Judge?
Well, that's what my notes said.
Okay, I had 11, but I might have
Wait,
to write
hold
it
on,
down. I'll put it up.
Madam Clerk.
I can make whatever. I mean.
We were just trying to find out what it was. I had 10 a.m. from July 23rd.
If it's 10, then.
Well, I want us all to be on the same page. I wrote down 10.
I'll make
Then
it
what does
10.
the system say? It will be 10 a.m.
Very good. Thank you, Your Honor. Have a good day. Va a ser a las 10 de la mañana, señora. Adiós. Take care. Oh.
Okay.
Have a wonderful day.
Is that it for me? The
That's
defendant
all.
has.
For me as well, yeah, that's all.
So we need 2 interpreters?
I think we can have the same one for defendant and plaintiff witness.
Así que vamos a necesitar 2 testigos. Creo que podemos tener el mismo intérprete para el acusado y el testigo. Your Honor, if the interpreter may, I don't know if the interpreter can interpret for a witness and the defendant if the witness is for the defendant, but if there should be an interpreter for each party.
Yes. Okay, thank you. We're gonna order 2 interpreters.
Sí, gracias. Van a ordenar 2 intérpretes, uno para cada parte. Gracias, su señoría.
Thank you.
Thank you.
All right. Now.
Are we ready to call? Oh, and then we'll go back to Mr. Martin.
The people are ready.
Good morning, Your Honor. Good morning. Robin McCoy on behalf of Mr. Eddie Galloway. I did talk to Mr. Galloway. He said earlier he said he had transportation issues, but he just said that he did get a ride and he should be here. He said it should be 20-30 minutes.
All right.
So I was just asking if we could pass this and just call in.
Now, in theory, yes, but we're gonna be jammed up in a little bit. So when he gets here, we may not be able to proceed. It just depends on what happens with these other matters that are set. It's now 10:12 and the matter was set for Mr. Galloway at 9:30. So we'll just, we'll see what happens when he gets here.
Okay, he has 2 cases, 2 exams. So he had one set for 9:30 and one set for 10.
I see. All right.
Okay.
Thank you.
All right, thank you.
Okay. Calling parties on Martin, case number 2061037, the people of the state of Michigan versus D'Angelo Devon Martin. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, assault with a dangerous weapon, felonious assault. Count 3, malicious destruction of personal property, $200 or more, but less than $1,000. Habitual offender, fourth offense notice. Judge, this is here on a motion hearing.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Neighborhood Defender Services by Ken Riggins, P82125, on behalf of Mr. D'Angelo Martin.
Okay. Mr. Martin, please state your name.
D'Angelo Devon Martin.
Thank you. Okay, counsel, did you want to proceed?
Yes, Your Honor. I filed a motion citing the statute for a 180-day motion. We are very sure that in accordance with the statute, that a letter was sent to the prosecutor's office on November 17th, 2020. That it was mailed out. I have verified the address. Now, Mr. Bloomers did file a motion yesterday, or at least I received the motion yesterday, and I cannot argue with what Mr. Bloomers said. There is no record of when or if that notification was received. I checked with the tracking number that I was given. I don't know if the court wants us to put the tracking number on the record, but there's no record of it being received. I do not know if or when the motion was received, assuming that the mail worked. It should have been, his 180 days would have expired by the time this case came. However, as officer of the court, I cannot say whether it was or not because I simply don't know. All I know is that Mr. Martin did what he was supposed to do on his half. He called, the letter was mailed. The letter was mailed timely, and he should not be, he should not be denied his speedy trial because of some snafu at the post office.
Well, I don't know if the court, I know I sent it a little late yesterday, so I don't know if the court had a chance to read my response.
It's in front of me, but if you could please respond.
Sure. Well, yeah, I think, Mr. Riggins and I both doing this kind of similar research. We both found, I spoke with a records clerk at the Cooper Street Correctional Facility. She pulled the file for Mr. Martin. She said their records showed that 180-day notice was mailed out on November 17th, 2020. However, that file also was missing, it was sent certified mail, and that file was missing a delivery receipt, which when you send something certified mail, it has to be signed for, and there's like a green card attached to the envelope, and whoever receives it must sign for it, and then that receipt is actually given back to the sender as confirmation that the letter was delivered to its addressee. That's kind of the whole point and beauty of certified mail, and why it's required to be sent, a notice of incarceration is required to be sent certified mail by the statute. So the MDOC, she told me she did not have that receipt, which would indicate that the notice had actually been delivered to the Wayne County Prosecutor's Office. I was also provided with a tracking number. I would hope it's the same as the one Mr. Riggins received. And it is written into the motion, and I did check that tracking number online and could not get any information about the letter that it at all, certainly none that it was delivered. So the people's position here is that, the statute very clearly says that the Department of Corrections shall cause to be delivered the notice of incarceration, and there is case law in People v. Davis, which is a published opinion from Michigan Court of Appeals 2006, that the 180-day period begins on the day after the prosecution receives notice. not notice is mailed out, not an attempt is made by Department of Corrections, but that the prosecutor's office receives notice. And then there's another case, People v. Rivera, which is not directly on point. In that case, the MDOC, they sent notices out, but they were sending them to like the district court and not to the prosecutor's office. But again, the point there was that because the notice was not sent certified mail to the prosecution, the rule could not be triggered. And so in this case, and the other part, I should have added this earlier, I'm sorry, this is sort of I spoke with APA Mahmoud Awad from my office, who is in charge of keeping track of these notices as they come in, and he searched his records and could find no record that he had ever received that notice. Typically, when we do get those notices, we then do our best to get the defendant queued up and get them arraigned. I can't say that we, I don't know offhand if it's ever, we received that notice timely and then not been able to do it on time. It's entirely possible human error is a factor, but in this case, we have no record that that notice was ever received. The MDOC can provide no record that we ever received the notice, that it was ever delivered to the notice was ever delivered to its addressee. And I think that, the courts have generally used a pretty strict reading of the statute and its requirements because the penalty here is quite severe, which is dismissal with prejudice. And so I don't think we have absolutely any way to verify that the prosecutor's office ever received this notice that we can, or that the court ought to then find that this 180-day period was triggered and that the case should be dismissed because we are outside of that period. So for that reason, the people are asking the court to deny this motion.
Okay, did you wish to respond?
No, Your Honor.
Okay, I've had an opportunity to review not only the motion, but the response to the motion. And that is the point, certified mail. It provides a confirmation of delivery to the targeted location. And without that confirmation, the 180-day period, as laid out in People versus Davis, I think that's case law that is on point. The 180-day period begins on the day after the prosecution receives the notice. And if there's no confirmation of receipt of said notice, then that 180-day period did not commence at that time. So I am going to deny the motion. It's a literal reading of what I have to consider before me. I can't insert facts that I think are sound good. I have to go by the four corners of the file. So with that being said, and there being no confirmation of receipt of that notice being sent, the motion to dismiss is going to be denied. Where are we in terms of future dates?
I believe what?
We have a live exam set for July 19th, it looks like.
Yeah, so that's going back. There was an issue with writting Mr. Martin. I went on the record about this at the last date, and then
well, we know where he is now.
Yes.
He's Wayne County, right?
Yes. And so, I mean, I think if we get it scheduled in fairly soon, then they will just keep him in Wayne County.
Okay, so Mr. Riggins, what date would you like within the next 7 days, or at least 7 days out to give 1 week's notice?
I have to be in your courtroom August 6th on another matter, so I can do it August 6th.
August 6th, Mr. Bloomers?
Is that a week from today?
That's 7 days from today.
Okay, that should work, Judge.
Okay, in-person examination next Friday, August 6th.
Judge, scheduled for 9:30.
At 9:30, thank you. Okay, we are all set.
Thank you, Judge.
Mr. Martin, I will set a visit up with you.
Said it again, Mr. Riggins?
I will set up a visit.
Okay.
Okay.
Okay. If that's who's out there, then it's almost 10:30, so. Judge, is Miss Bond up there?
Oh, let me see if she's in the waiting room. No, I don't think there's anyone in the waiting.
Okay. Okay, whoever's first, bring them in. Want to take a quick break? Yeah. Oh, sorry, I missed you. Galloway's here. Yeah, as soon as the court reporter comes back.
Okay. Well, you know, I wanted to ask, I have another client. So we're not set to here till August 17th. His brother died and he wants to modify the bond condition. So what do you guys do with that? Like, you want to
Type it, write it up and send it to me and then I'll put it on the docket.
Okay.
But just, yeah, send it to me and send it to whoever the prosecutor is.
Okay, if he just wants to go for like.
Yeah, just, yeah.
Okay.
If you'll send it in, I can get it on the docket within a couple days.
Okay.
Yeah.
Good morning.
Good morning, Mr. Harris.
I'm back on Marcellus Hunt. I need to determine from Mr. Slosky whether he's ready or not.
Yeah, he is not in the courtroom and he's not on Zoom, so as soon as
All
we
right,
can
well,
find.
we'll wait and see if they have, that whether they have witnesses or not.
I guess we're ready. Galloway. You just let me know when you're ready. I'm ready. Okay. Calling parties on Galloway. Case number 2061346, the people of the state of Michigan versus Eddie Galloway. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons, ammunition, possession by felon. Count 3, weapons carried concealed. Count 4, controlled substance possession, cocaine, heroin, or another narcotic less than 25 grams. Count 5, controlled substance possession analogs. Count 6 and 7, weapons, felony firearm. Count 8 and 9, weapons, felony firearm. Habitual offender, fourth offense notice, commission of a felony with a motor vehicle advisory. The defendant is also charged in case number 2057509. People of the state of Michigan versus Eddie Lamar Galloway. The defendant is charged with count 1, weapons carried concealed. Count 2, weapons, firearms, possession by felon. Count 3, weapons, felony firearm. Habitual offender, third offense notice. These matters are scheduled for preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Brenda Bailey on behalf of the people, P84009.
And good morning, Your Honor. Robin McCoy on behalf of Mr. Eddie Galloway, P63057. I would note that we were here previously on the 13th, but the matter was adjourned. I think it had something to do with the pandemic, like, or docket congestion, so, yeah.
Okay, are there any preliminary matters?
Your Honor, on case ending in 7509, people do not have all necessary witnesses to proceed with examination today. I would be needing a held in part on that one. I have one officer here, the other officer is on furlough. And I would need a held in part to get all information on that one. And then on both cases, Your Honor, I would be moving this court to enter Mr. Galloway's prior conviction of assaulting, resisting, obstructing an officer causing serious impairment with a sentencing date of April 18th, 2017. Therefore, Mr. Galloway is ineligible to possess any firearms.
And Your Honor, we would have no objection to that for exam purposes only, and we're here and ready to proceed on both cases.
Okay, do you have that marked?
Yes, Your Honor.
Okay, proposed exhibit number 1 will be admitted as people's exhibit number 1. And which case, 200613446, you're prepared to move forward with in full?
Yes, Your Honor.
Let's proceed. Anything further?
I think, I'm sorry, I didn't catch the case number, because there's a case from May, and there's a case from, there's the later case. So are we doing the May 27th case first, or are we doing the?
I am suggesting we proceed with the case that she has all witnesses prepared to proceed forward on, whether that's the May or the October.
I have all witnesses on the October.
October, okay, so call your first witness.
Yes, Your Honor. At this time, the people would call Officer carry on to the stand.
Can you please state your full name, sir?
Yes, Corporal Anthony Carrion,
And could you spell your first and last name, please?
ANTHONYCARRION.
Thank you. Could you please raise your right hand? Do you solemnly swear or affirm testimony you're going to give us the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. You can make your way over here to this little gate that will open up towards you. Watch your step as you come up. Once he's settled in his seat, you may proceed, Madam Prosecutor.
Thank you, Your Honor. Could you please restate your name for the record?
Corporal Anthony Carrion.
Are you currently employed at the Detroit Police Department?
Yes.
In what capacity?
Second precinct,
And how long have you been employed with the Detroit Police Department?
approximately 6 years.
Were you employed on October 19th, 2020?
Yes.
Did you work on that date?
Yes.
Were you by yourself or with a partner?
With two partners,
What were their names?
Officer Creech and Officer Wakey.
Were you in full or modified uniform?
Modified uniform.
Could you please describe to the court what a modified police uniform looks like?
Black shirt with green pants, markings, badge marking on the front, police marking on the back.
Were all three of you in that modified uniform?
Yes.
Were you on foot or in a scout car?
In a scout car.
Was the scout car fully marked or something else?
Yes, fully marked.
And could you describe for the court what that looks like?
It's an all black scout car with Detroit police markings on both sides of the vehicle with overhead lights on the inside.
What color is the lettering?
I believe it's black or gray.
Did your duties as a police officer take you to the area at or near Hubble and Linden?
Yes.
Is that here in the city of Detroit,
Yes.
county of Wayne?
Yes.
What, if anything, is at that location?
It's just intersection.
An intersection?
Intersection with houses around neighborhood.
And what brought you to that location?
It was a traffic investigation.
Were you on routine patrol or were you called to that area?
Routine patrol.
And where in the scout car were you seated?
Passenger seat, front passenger.
And who was driving?
Officer Wakey.
And where would that put Officer Creech?
In the back seat. I'm not sure which side, but he's in the back seat.
So at that intersection, what, if anything, did you observe?
We observed a silver Impala, tinted windows. We turned around the vehicle and observed that had an improper plate on it.
Was it doing anything else?
Not to my recollection.
What, if anything, did you do in response?
We performed a traffic stop in the vehicle.
So Did you turn the lights and siren on, or did someone else?
The driver, Officer Wakey did.
Excuse me?
The driver, Officer Wakey?
And you observed this?
Yes.
After the lights and sirens activated, what, if anything, did the Chevy Impala do?
The Impala pulled over to the right.
And after the Impala pulled over, what, if anything, did you do?
I approached the vehicle. I observed Officer Creech detain the passenger. He advised me there was open intakes in the vehicle.
Okay, so let's back up. When you approached the vehicle, were you on the driver or the passenger side?
I don't recall. I believe driver's side, but I don't recall.
Would you have put that in your report?
Potentially.
Did you come into contact with anyone after approaching the vehicle?
Yes.
Do you see the person that you came into contact with here in the courtroom?
Yes.
Could you please point to him and tell me something that he's wearing?
Green polo shirt.
May the record reflect the identification of the defendant?
Record will still reflect.
So you mentioned an open intox. Did you observe this open intox as well?
I did after I was advised by my partner.
So after being advised, would it be fair to say that you looked for it?
Yes.
And after observing this for yourself, what, if anything, did you do?
I ordered the driver out of the vehicle.
Did he comply?
Yes.
Was the defendant the driver?
Yes.
After the defendant exited the vehicle, what, if anything, did you do?
I believe I just had him step around in front of the car.
And then what?
And then my partner advised me he found a handgun and I detained him.
Which partner?
Officer Creech.
Did you observe Officer Creech retrieving this handgun?
Yes.
Where did he retrieve the handgun from?
It was right back to the left of the driver's side, to the left of the steering wheel, behind the light switch.
So on the driver's side of the vehicle, behind where?
Driver's side of the vehicle to the left of the steering wheel, there was a little light switch. It was right behind that.
What, if anything, happened next?
Driver was detained and passenger was both detained in our scout car.
Did you perform any investigatory searches on the law enforcement information network?
Yes, I ran the plate prior and I observed there was improper plate to the vehicle.
What about on the defendant or the passenger?
I know we did. I don't recall what the outcome was.
Did you have occasion to speak with the defendant after he was detained?
I'm sorry?
Did you have occasion to speak with the defendant?
Yes.
What, if anything, did you learn from that conversation?
In the vehicle, we didn't speak much, I don't believe.
Did you ask him if he had a concealed pistol license?
Yes, he did not. He does not have a concealed pistol license.
After the firearm was located, did you take possession of it or did Officer Creech retain possession?
I believe he retained possession, but I couldn't tell you for sure. I don't recall.
Do you recall the evidence tag number of the gun?
No, it's probably in my report.
Would viewing your report refresh your recollection as to the evidence tag number?
Yes.
Your Honor. Your Honor, permission to approach? Corporal, what have I just handed you?
It's a copy of my Sun Guard report.
So what I would like you to do is to review it silently to yourself and look back up at me when you're done, okay?
Okay.
So Corporal, does that refresh your recollection as to the evidence tag number for the firearm recovered?
It does. It's not indicated in my report. So I believe Officer Creech put it on evidence.
Okay. Did you observe Officer Creech put it on evidence?
No.
So what, if anything, happened after you placed the defendant and the passenger into your scout car?
They were both ticketed for the open tax, and passenger was released. And then we conveyed the defendant to the Detroit Detention Center.
And what, if anything, occurred after the defendant was conveyed to the Detroit Detention Center?
A couple loose, well, they were in a vial, pills of narcotics was found in his underwear.
Did you observe these, this bottle of pills?
Yes, they were found by the jail staff.
And what, if anything, was done with those pills?
They were taken, put on evidence, and conveyed to narcotics.
Did you do that?
Yes.
Do you recall the evidence tag number for the pills that were recovered?
I don't,
Would you have put it in your report?
potentially, but I can check.
Would it refresh your recollection to review your report?
Yes.
Okay, please do so. Is your memory refreshed?
Yes, I didn't notate it in the body of the report.
Did you take the pills to narcotics?
Yes.
And after you took the pills to narcotics, do you know what, if anything, was done with them?
I'm not sure what happened afterwards.
Do you know if any preliminary tests are conducted on these drugs, or suspected drugs?
I'm not sure what narcotics does with the drugs afterwards.
I have no further questions for this.
Cross-examination? Yes, Corporal Curran, was there anybody else in the car on that day?
Yes, there was a passenger.
There was a passenger, okay. And do you know, were you or any of your partners able to ascertain who the car was registered to?
I believe we did. I don't recall who it was.
Would you put that in your report?
Not necessarily.
So you're saying you don't know, or you need to have to look at your report?
I can check my report. I don't believe I know.
If you can look at your report, take a minute and then let me know when you're ready.
Yeah. Yeah, I didn't know.
Okay. And then, do you know, has the weapon been fingerprinted?
I'm not sure what happens after we turn it in as evidence.
Okay. And do you recall what my client was wearing on that day?
I do not.
Okay. And you said, I just want to clarify where the gun was located. It was You said it was near the steering wheel, or where was it?
To the left of the steering wheel on the driver's side, there's a light switch in the Impala. It was behind that.
So it was behind it, it wasn't in plain view?
No.
Okay. Okay, I have nothing further, thank you.
Any redirect?
No, Your Honor, no redirect.
Thank you. Corporal. Any further witnesses for the prosecution?
Your Honor, at this time, the people would call Sergeant Willie Smith. Your Honor, Sergeant Smith is testifying in another courtroom.
Okay, anything else we can call? Mr. Burmers, did you have anything?
Yes, I think we can call Taylor.
We're gonna pause on this matter for just a moment.
Good morning, Your Honor.
Good morning.
I just had you looking for me?
No.
Oh, you're not? Okay. I'll go back out home.
Mr. Harris was up there just entering into a waiver.
Yes, I suppose we are looking for you then.
I have to find the file again though.
So,
Is this Taylor?
no.
No?
Ms. Marsh is in the exam next door.
Okay, y'all just waiting for me today.
I know this guy's name.
But
Who's this then?
this is Harris.
Okay.
Good morning, Mr. Strong.
Good morning, Your Honor.
How are you?
I'm good.
Can we call Harris?
I'm trying to
Oh, I
find,
mean, I was really asking the prosecutor. Are we,
Good morning, Your Honor.
are you on Harris?
I am, Your Honor.
Is it something of a quick nature or?
I would expect so. If I could just have 5 minutes to check out in the hall.
Mr.
I haven't seen my officers yet. I understand they haven't got there. If I could just call out in the hall, see if they're here.
Okay.
Thank you, Your Honor.
I don't know. Judge Ms. Bond is here regarding an adjournment that the prosecution has requested, that her client wants to continue with the August 2nd date. Can I call that real quick? Ms. Bailey's case. Calling parties on Andrews. Case number 2061513, People of the State of Michigan versus Darius Andrews. The defendant is charged with count 2, assault with intent to do great bodily harm less than murder.
I'm on here now.
Count 3, assault with a dangerous weapon, felonious assault. Count 4, assault aggravated.
Hello?
Judge Carter is scheduled for an exam on Monday.
Okay.
Hello?
Hello. Hello.
Can y'all hear me?
Yes, we can.
Oh yeah, I'm on here. I've been trying to log in and download the app. This is Rayshawn Andrews. I've been trying to get on here since 8:15. I didn't even call down to the 36th district, and they was trying to walk me through how to do it, but ain't nobody answering the phones. But I finally through. I was just watching y'all on YouTube.
Just, if you'll just call me on my phone number, I can talk
Can
to
you
you.
call a telephone number? Do you have a pen and paper?
Who, me?
Yes.
Hold on. Yeah, Maya, find it. Okay, I got a pen and paper.
I already appeared for him, so he just needs to call me.
But I'm just asking as an aside, does he have any relation to the dairies?
No, it's a separate matter.
965-2282, sir.
313-965-2282.
Yeah.
And who is this I'm calling?
The clerk. Now listen, the next time in the event you have to come back into Zoom court, we're kind of in the middle of doing things. So the next time you come in, don't come in so hot. I mean, you gotta mute your microphone and
I'm
just,
sorry. Yeah, I was scared. I'm thinking I don't want no warrant out for my arrest because my cousin was pulled over last night in Detroit. Wayne police ran my name and they said I had an active warrant. I'm like, how if I'm out on bond? But they said I have an active warrant, so I'm trying to.
All right, I appreciate that, and I would be frustrated too. So just call the number. You're gonna get the clerk right here in the courtroom. She's gonna talk to you.
What time? When should I call now?
All right now.
Okay, thank y'all.
You're welcome.
Sorry about
All
that.
right.
Okay.
In a matter of first serious and appearances.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
And good morning, Your Honor. Janet Span, P43281 on behalf of Darius Andrews.
Okay, and your client, is he present or no?
He is not present, Your Honor. I wasn't sure what time we were going to handle this, but I am in touch with him.
Are you requesting to waive his presence?
Yes, I would ask the court to waive his presence.
So ordered. What are we calling the case for?
Well, Your Honor, on July 6th of 2021, the people filed a motion to consolidate the remaining 3 defendants on this case. On July 6th, I provided a copy to the court, as well as to Ms. Bond, Mr. Tuttles, and Mr. Glanda. To date, only Mr. Tuttles has responded to my motion, indicating that he was fine with it, Your Honor. I requested it put on to be heard, and received nothing back until earlier this week, when I was told that defendants Julius Hill and Dennis Hill had been moved to the October date, Your Honor. The people moved for the consolidation of this case to be heard all on the same day. All 3 defendants don't have to be heard at one time. Your Honor, people just would move for, doing 2 at one time and then the last one the last time. This case has been going on for quite some time, Your Honor, and the complaining witnesses have appeared each and every single time. There are 7 defendants total, Your Honor, and save for 2, which I did motion the court to combine at the last time this case was up. Each and every single defendant had a different preliminary examination date. Your Honor, I believe that in terms of judicial economy, as well as fairness to the complaining witnesses, that the remaining 3 defendants be put on the same date, Your Honor.
Okay, so before you respond, Ms. Bond, and I do want to give you an opportunity to respond, if you were somebody perhaps watching these proceedings, you might think, my goodness, why would this judge put 7 defendants at 7 different dates? So let me take an opportunity to just clarify that in the event that happened, which apparently 3 of the defendants are already across the street, they obviously were arraigned at different times. So there has to be fullness to the record so we can have context. So people wouldn't be, particularly the complaining witnesses, thinking, why would Judge Archer do such a silly thing to inconvenience me? So that's first. The cases as they come before me and individuals are arraigned, we handle them one by one. They were apparently not all arraigned at the same time, which causes, a little bit of challenge in scheduling examinations, coupled with the challenges that already exist. So that leaves us with, I believe, 4 defendants or 3?
3 defendants, Your Honor.
3
4
defendants.
have already made it over to the circuit
3
court.
defendants, and I have no problem. It makes sense. I'm not certain. It sounds as though the posture of the prosecution is that the court is, you're up against the wall with the court.
No,
I think it makes sense. I think we should have everything on the same day. But what I'm not going to do, if there's an exam scheduled for Monday, which I think I heard off the record, I'm certainly not going to force defense attorneys, if they're unable to be here on Monday, to hold an exam on Monday. But I guess we just need to find out what's going on. If Ms. Spond is representing one of the defendants, we've got 2 other attorneys that aren't here right now.
Well, Your Honor, the issue arose earlier this week. The court's clerk emailed me to notify that the Hills had been moved to October and asked that if I wanted Andrews to also be moved to October, which is the crux of this motion, is that I wanted one of the 3 dates that were scheduled to be picked for all 3 defendants.
First of all, I don't see that this is a problem. I think this is just a matter of scheduling, but the posture, the way that this is being postured sounds like this is a problem. I don't think this is a problem. I think we just need to all come to the middle and solidify a date for which is going to be good, not just for Ms. Spond, but for the other 2 attorneys as well.
Well, yes, Your Honor, if I could just finish the argument.
I'm not sure why it's an argument, because the way you're posturing it, hold on one second, is as if the court is bucking what you're suggesting. For judicial economy, it does make sense. So this isn't a situation where the court is disagreeing with the need for judicial economy.
And I'm not trying to say that the court is, Your Honor. The
Okay.
issue is coming with Ms. Spond, who never responded to my motion, never contacted me, and yesterday or the day before contacted the court's clerk to indicate that the October date was not okay, that her and her client wanted it to be held on Monday, with absolutely no conversation with myself.
And I will also say, Ms. Spond, you are going to have an opportunity to respond. But yes, judicial economy is important, but that's also balanced between, again, different defendants being arraigned at different times. And in the event there is a split up, it is not ideal, particularly when witnesses have to come in on separate dates. But if it is something that is objected to, the court is not going to force one of the defense counsel, it sounds like Ms. Spond, who wants to proceed with an exam that she has set to go on Monday. But let's hear what Ms. Spond has to say.
Okay, Your Honor, just in response, I did receive the motion, but attached to that was also, I believe, an email requesting a date for a hearing on the motion. I did not respond because I never received anything back that the motion was scheduled to be heard before you. Your clerk called me yesterday and said that my client Darius Andrews is up on Monday. She requested if we would have any objection to consolidating it on October 15th. I did speak with my client yesterday, and I called your clerk back and I said that my client preferred to proceed on Monday. He would like to get this over with. It was scheduled. The other part of that is a scheduling conflict, Your Honor. I do a docket in Wayne Juvenile with a referee on Wednesdays and Fridays. So it's kind of difficult for me to make myself available to your court on Fridays. so for that reason, I said we preferred to proceed on Monday. And then your clerk instructed me to sign on today so that we could discuss the matter.
Thank you so much. Now, the other two defendants are scheduled for the same date in October.
Yes, ma'am.
We're going to proceed in this manner. Is it the best judicial economy scenario? No.
Well,
It would cause complaining witnesses have to come on two separate dates. But given the scenario, again, I want to make sure we're painting a picture here that's appropriate. The defendants were arraigned on different dates. They were brought before the court on different dates. So that again presents a challenge. If Madam Defense is prepared to proceed on the date that it's teed up for, which I believe is Monday, and she has a scheduling conflict to boot for the October date, notwithstanding the fact that her client is not in custody, I'm not going to force Madam Defense to move from August 2nd to October, whatever the date is. I am not going to do that. So the motion to force Madam Defense to go to October date is denied because of the wide range of time between which the defendants were arraigned. So,
Your Honor, I'm not even sure that the people would be able to proceed on Monday with three.
oh, now that's a different issue. And why is that?
Your Honor, I'm not sure if the witnesses have actually been subpoenaed for Monday's date. I had it as August 8th, not August 2nd.
Oh, is it August 2nd or 8th? I thought someone said Monday, so I'm assuming August 2nd.
It is on Monday, Your Honor. However, all of the people's records indicated the 8th, which is what is in my motion. So
August 8th is a Sunday.
That's what, I will make attempts to try to get the witnesses here on Monday, Your Honor.
Okay. Can I have an ROA, an updated ROA on Darius Andrews?
And Your Honor, this matter was set for August 2nd a long time ago. I mean, if the witnesses are unavailable, I'm not saying that I necessarily have an objection to an adjournment, but just that it be to a date that I'm available.
That would be very amenable to the people, Your Honor, to try and get it on a date closer to when people have proper time to notify the witnesses and they're on. Even to back-to-back days.
Okay, so again, I just want to be very clear. The issue is more so that the prosecution is not ready to proceed on Monday. That is more of the issue than there being an argument for judicial economy. And now that we've talked this through,
yes,
this is very clear. I appreciate you bringing it to the court's attention. Ms. Bond is indicating she has no objection to the date so long as she can be here. But that seems to be real. There's background noise, and I don't know where that's coming from.
Check out the Audible website.
Ms. Bond, can you please your microphone?
Yes, I apologize, Your Honor, for some reason.
Your Honor, I didn't want to make it seem as though the bigger issue is that we're unprepared on Monday. The biggest issue is judicial economy and a motion that was filed.
And that motion was denied.
I know, Your Honor, but the motion was filed 3 weeks ago.
That motion was denied, whether it was 3 weeks ago or not. This matter was set in January. This exam date, well, I mean, according to what I'm looking at, unless it's wrong, January 27th, this matter was set for an August 2nd exam. And the reason being that this exam date differs from the other two defendants. Again, I hate to be redundant, but there are people who are watching this who have no idea of the system and how things happen. Individuals were brought to be arraigned at widely different times, which is why some are across the street, some are still pending here in district court. The motion is denied for the reasons I stated on the record. However, it really sounds like again, in my estimation, the real problem is that you haven't, well, you're not uncertain as to whether or not the witnesses have been notified. Therein lies the issue, and Ms. Spahn has said in response to that, now that I have a heads up, let's move it to a date for which you can have an opportunity to make confirmation of subpoenaing the witnesses, so long as it doesn't conflict with her Fridays. So we're really all on the same page. Her client is not in custody, so she seems very agreeable. Thank you, Ms. Spahn. In a spirit of cooperation, I appreciate that. Let's find a new date.
Yes, thank you, Your Honor. But I do agree. I mean, this matter was set in January. I have no idea why they would not have been subpoenaed.
October 18th, 10:30.
October 18th at 10:30. Is that one day before the other matter?
I'm not even sure.
I believe it's several days after, Your Honor.
Oh, okay. October 18th, is that a date that works for your calendar?
That's a Monday.
That's fine, Your Honor.
And Your Honor, at this time, I'm notifying the court that by the end of the day, I will be filing a new motion to move Julius Hill as well as Denise Hill the 18th.
Okay, so make sure you send said notice. Could you please mute your microphone, Ms. Spahn? Can you please send that notice, that motion, rather, to the other two defense attorneys so we can all sit down and have a conversation? It's not, I don't think it's going to be met with a tremendous amount of angst from the defense attorneys. I don't think it's going to prompt a huge argument. So we just need to tee it up so everybody can be on the same page. It's well in advance of the exam date in October. And I think, again, in the spirit of cooperation, it's gonna be fine. We just need to confirm a date. It would obviously be, I would prefer at two separate times. Two-bagger at one time, the other one at the next time, because in this courtroom, unless the restrictions are lifted, I am going to be abiding by the restrictions of the limitations on the number of people in the courtroom. So we can set one for one time and the two-bagger for another time on the same date. This, Mr. Andrews is going to, what did we say, October 18th?
Yes.
At what time?
I don't remember what I said, Judge. I think at 10. What did I say, Fee?
I have 10:30.
October 18th at 10:30. Certainly want to make it as easy as possible as it is for as it can be for the complaining witnesses that need to come into the court. It makes complete sense.
All right, Your Honor, I will notify my client. Are we all set then?
Yes, ma'am.
Okay, thank you so much. Have a great weekend, everybody.
Thank you, Ms. Bond.
You too.
Are we ready on Hunt and Harris?
I suppose as ready as the people are gonna be today.
Mr. Harris, are you available?
Yes, I'm waiting on Marcellus Hunt to see if the people.
Mr. Sessions.
Yes, I'm here. I know you
Hold
are.
on,
Mr. Hunt.
one moment, please. Hold on.
The question is whether the prosecutor is ready or not.
Okay, thank you. Hold on.
parties up on Zoom.
Calling parties on Hunt and Harris, case number 2060050. The people of the state of Michigan versus defendant number 1, Marcellus Therese Hunt. The defendant is charged with count 1 and 2, false report of a felony. Defendant number 2, Devontae Harris, is charged with count 1 and 2, false report of a felony. This matter is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Swelsky on behalf of the people, P83677.
And Judge Lyle Harris standing in for the retained counsel of record, Gary Janadia, and I'm doing that with Mr. Hunt's consent. State your name, Mr. Hunt.
Marcellus Hunt.
And I'm
Thank you.
doing.
And Mr. Strong, I'm sorry, could you put your appearance on again, please?
Yes, Your Honor. Ronnie Strong appearing on behalf of Mr. Harris.
And could you state your name, sir? Thank you. All right, today is date and time set for preliminary examination. What is the status of what we're doing here?
Your Honor, at this time, the people are not prepared to proceed. I request an adjournment in this matter. I found out late yesterday that the officer in charge in this case has recently retired. I sent subpoenas directly to him, some of which had to be forwarded to officers outside of the DPD, which I don't have direct contact for. Accordingly, it's my understanding that those subpoenas were not received by the officers. I would ask for an adjournment in order to secure those officers present here for it.
Is there a motion?
Yes, Your Honor. We would move to dismiss at this time.
Mr. Harris?
As would I.
Motion to dismiss is granted. It's currently 11:19 in the morning. These matters were set for, is it 10?
10:30, I believe, Your Honor.
10:30. And the prosecution is not prepared to proceed. I am going to grant the motion to dismiss on both Hunt and Harris. The matters are dismissed without prejudice. Now, it's really important for you to understand, Mr. Harris and Mr. Hunt, that the matter is dismissed, but there's all the bells and whistles surrounding the word dismissal, but after it comes some trailer language. The trailer language after the word dismissal is without prejudice. And what that means is that it can be reissued, which might be shocking to hear. So if you have questions about the fullness of that concept, please make sure you speak to your respective attorneys. They will explain it to you in greater detail. Matters are, again, as it relates to both defendants, dismissed without prejudice. Mr. Hunt, do you have on a GPS tether, sir?
No, I do not.
Mr. Harris, do you have on a GPS tether?
He does not, Your Honor.
Thank you. Mr. Harris, Mr. Lyle Harris, do I have permission to sign your name to the order of dismissal as the moving party as it relates to Hunt?
Yes, Judge.
And defense counsel, I will need your signature, Mr. Strong, on the matter pertaining to Harris. Is there anything further?
Nothing from the people.
Nothing by the defense, Your Honor.
Okay, Mr. Harris, we're going to forward a copy of this dismissal to you. And Mr. Strong, you're going to get your copy in here in the court in just a moment. I'm just preparing it right now.
Can you send that to Attorney Gary Janadia?
I will take care of it, Harris.
Okay, thank you.
in custody. Will Morris, Mr. Bickert's gonna be in there.
Oh, he's in right
It's
now.
gonna be a dismissal. Is he out there?
Mhm.
Okay.
Mr. Bickert, are you here?
Well, we have to have this, person brought up. And then we'll call it.
Yes, did you call me?
Yes.
We're gonna bring, Mr. Wills up, Mr. Morris up.
Okay.
So I guess we can go back to.
Okay, we're back on the record in the matter of people versus Eddie Galloway. 2006136. Your next witness.
Your Honor, after a brief discussion with Ms. McCoy, the people are gonna be moving to enter, people's proposed exhibit to the laboratory service, containing an identification of the pills found on Mr. Calloway, at the detention center, Your Honor, and would ask that it be stipulated to, for exam purposes only.
Non-defense?
That's correct, Your Honor, for exam purposes only.
Okay, is that marked
Yes, Your Honor, it is marked.
as,
People's, exhibit 2.
okay, people's proposed exhibit number 2 will be admitted as people's exhibit number 2. Did you want to publish that to the court?
Yes, Your Honor. Permission to approach,
Yes. Okay, any further witnesses for the prosecution?
No further witnesses for the prosecution.
Madam Defense,
None for this defense, Your Honor.
is there a motion?
Your Honor, at this time, the people would move for a bind over. We heard from Officer Carrion today, who indicated that he and his partners conducted a traffic stop. And during this traffic stop, Officer Carrion observed an open cup bottle. He didn't specify, but something that was an open intoxication, Your Honor. During this stop, Officer Carrion observed a firearm be recovered from the driver's side of the vehicle. I believe he indicated to the left of the steering wheel. Adjacent or behind a light switch, Your Honor, the defendant was driving the vehicle, Your Honor. Due to his prior conviction of assaulting an officer causing injury from, I believe it was 2017, he is unable to possess a firearm, Your Honor. After being detained and taken to the Detroit Detention Center, prior to his being admitted there, he was searched and several pills were located on your person, Your Honor. These pills were analyzed and determined to be oxycodone, Your Honor. The defendant does not have, or no evidence has been provided that the defendant has a prescription for oxycodone. Your Honor, he is ineligible to carry them. Your Honor, Adderall was also located, as you can see in the People's Exhibit 2. These items were recovered and put onto evidence and taken to the Narcotics Division, Your Honor, where they were analyzed and tested and were preliminarily determined to be oxycodone and either Adderall or a generic amphetamine Schedule II drug. For these reasons, Your Honor, the people have established probable cause in this matter and ask that this honorable court find over.
Madam Defense?
Yes, Your Honor, we would object to the bind over. There was testimony, but there was also testimony that there was a passenger in the car. So we're going to object, although we know that there's a question of fact and a part of fact.
Thank you. This is a probable cause hearing as it relates to this, and had an opportunity to listen to Corporal Carrion testify as to what he observed, his observations and recoveries from the date in question, October 19th, 2020, and his identification of the defendant, coupled with the count, I'm sorry, not the count, but the People's Exhibit number 1, as well as People's Exhibit number 2, which would include, number 1 was the prior conviction, number 2 was the lab reports confirming what has been articulated here by the prosecution as it relates to the narcotics that were recovered from the defendant. So this is a probable cause hearing, and the burden has been met here by the prosecution to establish by a probable cause standard that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes. That would include counts 1 through count 9 as charged in the complaint. So I am going to bind over to the circuit court for further proceedings with an arraignment date of August 20th. Before we begin with the next Galloway file, I think they're gonna bring this gentleman in. Mr. Bickert, are you there?
Yes, Your Honor.
Calling parties on Morris, case number 2159355. The people of the state of Michigan versus Will S. Morris. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, domestic violence. Third offense notice. This matter is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
I'm sorry, Your Honor. May I please court, Your Honor, Tyrone Baker, appearing on behalf of Mr. William Morris.
And your client, could you state your name?
Will Morris.
Thank you. Today's date and time set for preliminary examination. Are we proceeding to an examination?
Your Honor, at this time, the complaining witness, Diamond Gilliam, is not present. She was subpoenaed to be here for a 10 a.m. preliminary exam. Without her present participation, the people are unable to go forward as to count 1.
Your Honor,
Mr. Bickert.
I'm sorry, Your Honor. And Your Honor, based on that, I would make a motion respectfully to dismiss the matter.
It is currently 11:30 in the morning. This matter was set for 10 a.m. and the complaining witness has failed to appear according to the prosecution. So I'm going to grant that motion to dismiss. The matter is dismissed without prejudice, which means it is possible that the prosecution can reissue in this matter. Do you understand that, Mr. Morris?
Yes, I do.
Okay, so count 1 is going to be dismissed without prejudice. Count 2, the remaining misdemeanor, is going to be set for a pretrial before Judge Garrett on August 13th.
And Your Honor, can I ask, do those misdemeanors that carry on, is my understanding they go to the misdemeanor defender's office? Is that correct? Or do they remain?
I believe they will be there to represent him.
What was that date again? I'm sorry.
August 13th.
Thank you.
Okay, we're all set.
Thank you, Your Honor. Good luck,
you,
Mr.
sir.
Morris.
Oh, is that Taylor?
Yes.
Judge, we got another dismissal.
Okay.
I can.
Oh, Mr. Vick, oh,
Oh, I'll call him.
Sorry.
I'll call him right back.
I also, I guess, let's see. I see Mr. Humphreys on. I have a Zoom exam with him. I just want to check the complaining witness if I can call out Judge. Deani Moore, is there a Deani Moore on the Zoom? If so, please unmute yourself and state your name. Deani Moore. Okay, so we can do Taylor and Anthony.
Yeah, that's okay, and I will email a copy from you, okay? Okay, no problem. All right. Okay, all right. It's okay if you, okay, thank you.
Morning, Mr. Anthony.
Taylor.
Good morning.
Taylor and.
Okay, I'll call both of them, and then that'll be a judge, other than the one we're doing right now.
Calling parties on Taylor. Case number 2157102. The people of the state of Michigan versus D'Angelo Taylor. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapon, felony firearm. Count 3, domestic violence. This matter is scheduled for a preliminary exam.
thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Carol Chapman Marsh, P31887 on behalf of Mr. Taylor, who is present behind me.
Good morning, and could you state your name?
Angelo Taylor.
Thank you. Today's the date and time set for a preliminary examination. Are we proceeding to an exam?
Your Honor, this time the complaining witness for counts 1 and 2, LaDiamond Williams, is not present in the courthouse. She was subpoenaed to be here for a 10:30 preliminary exam. Without her presence participation, the people are unable to go forward at this time as to counts 1 and 2.
Non-defense?
Your Honor, we will move to dismiss at this time.
Okay. That representation having been made by the prosecution, I am going to grant the motion to dismiss. Keep in mind that I am dismissing as it relates to the 2 felonies, counts 1 and 2. Count 3, the domestic violence misdemeanor, is going to be set for a pretrial before Judge Garrett on August 13th.
Thank you, Your Honor.
Do you have on a GPS tether?
You have a tether? No, he does not have a tether now.
Okay. We just need your signature, Madam Defense, on this order of dismissal as the moving party. And you'll be all set. You can have a seat in the hallway, sir.
Thank you.
You're welcome.
Calling parties on Anthony.
Actually, I just got informed by the officer my witness is here, even though this was a Zoom exam. So we may need to adjourn, but.
Okay, I'll set it aside. Just let me know.
Mr. Humphreys?
Yes.
So I just was informed that the complaining witness actually showed up in person, even though it was a Zoom exam. So was this going to be a hold or a waive? Because if it's a waive, I think we need to do it, and I don't know if we need to adjourn if it's going to be a hold. Or a hearing. So the complaining witness is present here in the courthouse. So I don't know if you were planning to waive if she showed, because we can do that. Otherwise, I don't know if we need to adjourn it because we're all in different places, or how you want to proceed.
May I speak to my client in the breakout room real quick, John? Is that possible?
Yes. Your client is?
Mr. Hampton.
Okay.
Always something in here.
You can't make this stuff up. Mr. Aisha.
I had to to unmute myself after that. That might be the most unbelievable thing I've heard on Zoom in the last year and a half.
Mr. Aisha, was that you?
No. I was muted at that time. I want to be very clear about that, whether we're on the record or off. But God bless him. I think we know who that culprit was, the person that just logged off. But far be it from me to point that finger. Judge, I wanted to jump on. I don't want to have a bunch of ex parte. I've got an exam on Monday, scheduled for 10 o'clock. It's a live exam. My 2-year-old broke her foot on Monday, and I've got an orthopedic appointment on at 8 o'clock Monday. So I might just be a little bit late. I don't know how heavy the docket is, so I wanted to check in if I could today.
How did she do that?
She was getting ready to go down a water slide in a pool and thought it was better to jump off the water slide than go down it. And I think quickly learned otherwise.
Oh.
Yeah. So hairline fracture. I at the risk of getting CPS called on me, I'll just say that it was a freak accident that really couldn't be avoided.
I'm so sorry to hear that.
Thanks, Josh. She's a trooper. She got a lot of toys to make up for it. So I think she's handling it in stride.
Wow. Okay. Yeah. So what matter? What's the name on it?
It's Jaquan Dixon.
Is that a general? That's a general warrant case.
Is it in custody?
He's out of custody, Your Honor.
All right. What time is it set for?
10 a.m.
Is that your case or Miss Yafuki's case?
Miss Yafuki will be here on Monday. However, we're both the general warrants. So I have no problem with hearing on it and doing something with it today.
Many full policy, all right.
Would you like a new date?
I'm open to that. I've got to be down at the court. I've got a 12 o'clock exam with Judge King, so I'm coming down regardless. I just again, I anticipate just with traffic and Dr. Zaltz, I don't know how busy he is, that I might just be a little late. So the new date's fine. I don't know if it's an issue for the people. I didn't want to. I know the court set this out months ago, so I didn't want to make it a big issue. But a new date's fine if the court's got dates coming up or.
Set the time back an hour to 11.
That's completely fine by me.
Okay, I can just do that, Judge.
Do you have a problem with adjourning it from 10 to 11?
No, ma'am.
Okay. So you.
Judge, and I'm sorry, I can't see I think I may know who it is, but who is the APA?
Today it's Bryn Bailey.
Okay.
On Monday, Emma Yafufi. I'm gonna text her and let her know that this is being pushed back an hour.
Okay, great.
No issues with that.
Perfect. If there's a problem for one of your witnesses because of that, and you need to move it or whatever, I'm amenable to that. But I don't want to make a big issue if we don't need to have one.
No, of course not. And I thank you for the heads up. It's greatly appreciated, and I hope your daughter's appointment on Monday goes well.
Thanks so much. Sorry to barge in today.
See you, Vincent.
You all take care. Bye-bye. Have a nice weekend.
Bye.
Is there something else I can call? Or does it-
mute your audio.
Mr. Callaway's cases this morning, one of the officers I found out is on furlough. They are necessary for finishing testimonies at this time. People would be asking for help in part.
Did you care to respond?
I thought it just, because there's been testimony today, I'm not clear if that other witness would be cumulative or I would object to adjourning this.
What was the reason that you needed another, well, could you explain why you needed the adjournment?
Your Honor, I believe that it wouldn't be necessarily cumulative, as this court heard. The officer that testified was, he estimated roughly 30 feet away when the firearm was recovered. And the officer that the people would intend to proffer would have been, would be either the officer that recovered it, or would have been adjacent to the officer that recovered it.
So you do not feel the testimony that's on the record at this time is sufficient for a bind over?
Your Honor, that is an excellent point, and upon consideration, I would actually withdraw the motion for a held in part and instead change it to a motion for bind over.
Madam Defense, your argument?
Okay, so well, we're gonna object obviously to the bind over. We did hear testimony from Officer Wiggins. He said he saw my client in front of the liquor store with, first he said it was armed, but then he said he believed he was armed. Then there was testimony that it was Officer, he said first Muick who located a firearm, and he saw Officer Muick do that. And then upon further questioning, he said he wasn't sure, there were officers blocking him. So we would object to the bind over for those reasons.
Thank you. So we've heard testimony from Officer Wiggins. He laid out what happened on May 27th, 2020, where he observed outside of the liquor store there on Greenfield. He observed the defendant, who he clearly identified here at court, standing in front of the liquor store with what he believed was a firearm, a handgun in his waistband. He further described it on cross-examination as being L-shaped, and that in his belief it was a firearm. Based on that, he had approached, along with his partners, Mr. Galloway, and at that time, Mr. Galloway fled on foot rather quickly, running away, and a chase ensued. The defendant was attempting to climb a fence when they caught up with him, when this Officer Wiggins rather caught up with him, and a firearm was recovered. Yes, there was the question that kind of remained in the air with regards to who, on cross-examination, who actually recovered it. Officer Wiggins said he did not recall once he was cross-examined. The initial statement by Officer Wiggins was that it was Officer Muick that had recovered it. This having occurred back in May of 2020, I'm not certain how many stops this officer has had in the interim, but this is over a year ago. What Officer Wiggins was not uncertain about was that the defendant was the one who he identified in court was the individual that this matter pertained to, and that he saw what he believed to be a firearm, that he pursued, that he was addressing the matter in the fashion in which an officer typically would, under these circumstances. The defendant fled, caught up with the defendant as he was trying to climb the fence, and that a firearm was recovered. He never wavered on whether or not that firearm was recovered, nor did he waver on the closeness that that firearm was recovered from in relation to where the defendant was attempting to climb the fence. That firearm was then placed on evidence tag number was provided. Certainly the prosecution has met their burden here by a probable cause standard. There is a question of fact that does exist here, and the matter will be bound over to the circuit court for further proceedings. The arraignment on information date is going to be August 20th at 9 a.m.
Okay, thank you.
Thank you.
Thank you, Your Honor.
Oh, thank you all. Have a good weekend.
You too. Have a good weekend. Be safe.
Judge, do we need Mr. Morris back up here to recall this?
If it's possible.
I can get him back up here.
Let's ask Mr. Vicker, did you want to address Mr. Morris's bond?
Yes, Your Honor. I don't think, I would submit, I'm not so sure that Mr. Morris's presence would be necessary. I would.
Okay.
We're
gonna call-
given.
Recalling Will Morris, case number 2159355. This case was previously called in full.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
May it please the court, Your Honor, Tyrone Baker, appearing on behalf of Mr. Morris. Your Honor, I ask the court to allow me to waive his presence at this time, if
So
the court feels fine. Your Honor, simply put, the felony case against Mr. Morris has been dismissed. I would ask the court, given the remaining charges, to consider a personal bond for Mr. Morris. I don't see, that's my motion.
I'm sorry, Judge, I made an error here. The count 2, the DV was actually charged as a felony.
Oh, so it was a third offense.
So it should have been dismissed as well. And
Okay.
that would be the end
I'm
of the
so glad we caught that. So, actually, the whole entire matter is going to be dismissed, and that's not an issue unless he has another hold. The bond, I think it was 15,000, 10%, that's going to be canceled as the matter is dismissed without prejudice. That would include counts 1 and count 2.
Understood, Your Honor, and I apologize for not catching that as well.
Okay, we're all set, no worries.
Thank you.
All right, thank you.
Hey, Jacob.
Hi, Tammy. Can I inquire about Antonio Casey? I understand there was a new defense attorney that was supposedly appointed. I think it appeared and then disappeared.
Oh, I thought that was, I didn't know that was your case. I thought that was,
Well, there's no auto theft charge yet, but I expect that there will be.
Antonio Casey?
Yeah, there's a co-defendant scheduled for exam on December 1st.
It was scheduled the same day.
Oh, what?
Mr. Gopal's the attorney.
Okay, thank you. I'll make note.
Okay, is that for the morning?
We have Mr. Humphreys is still up there. Did I call it already? I feel like he left. No. Is he there?
I don't think we formally called it. The witness had just shown up. I saw him come back and then must have stepped away. There he is.
All right. Calling parties on Anthony, case number 2156887. The people of the state of Michigan versus Tora Ricardo Anthony. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, assault with a dangerous weapon, felonious assault. Count 3, domestic violence, habitual offender, second offense notice. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good afternoon, Your Honor. James Humphreys, P38930 on behalf of Mr. Tora Anthony.
Thank you. And Mr. Anthony, please state your name.
Tora Anthony.
Okay, we are here today for a Zoom exam. Looks like that's how it was set. Mr. Prosecutor?
Yes, Judge, and the witness, Deanne Moore, was subpoenaed to be here on Zoom. However, there was some kind of a mix-up, so she did appear here on time. However, she is in person, so we're kind of stuck in a hybrid mode, and I inquired before the case was called about what Mr. Humphreys, how he wants to proceed, so.
Mr. Humphreys?
Your Honor, can we have the complaining witness step into the courtroom so that I can see them by chance?
Yes.
I'll get it right now.
Good morning to you, or good afternoon, rather. Okay, we have the complaining witness in this matter present in the courtroom at the podium. Mr. Humphries, what's your pleasure here?
Yeah,
Oh, I'm sorry. Okay.
I'm sorry, Your Honor.
State
At
your
this
name.
time, Your Honor, Mr. Anthony,
Mr. Humphries, just 1 second. Could you state your name?
My name is Leonie Moore.
Thank you. Okay. Mr. Humphries.
Your Honor, on behalf of Mr. Anthony, he wishes me to ask the court to present him with the waiver of the preliminary examination. I've explained to him what the purposes of the exam are, understanding same he's indicated to waive. Is that
Any
correct,
objection?
Mr. Anthony?
No objection from the people.
Okay. So, Mr. Anthony, do you understand the allegations against you?
Yes, ma'am.
Do you understand that you do have a right to a preliminary examination?
Yes, I do.
Do you understand that if an examination did occur here today, that the prosecutor would need to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes? Do you understand that?
I'm sorry.
Okay, do you understand that if an examination did occur here today, that the prosecutor would need to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes? Do you understand that?
Yes.
And if the prosecutor were able to clear that hurdle, the matter would then be bound over to the circuit court for further proceedings. Do you understand that process?
Yes.
The representation's been made here by your attorney that you wish to waive your rights to a preliminary examination. Do you understand that that means that this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an exam at this phase?
Yes, ma'am.
And is that how you wish to proceed?
Yes.
Thank you. Are you doing so voluntarily?
Yes, I am.
Thank you. I do find your waiver to be knowingly and voluntarily given. The matter will be bound over to the circuit court for further proceedings with an ALI date of August 20th, 2021 at 9 a.m. We're going to forward a copy of the examination waiver form to you, Mr. Humphries, and we need your signature on it. And if Mr. Anthony is going to give you his permission to sign his name, we will also need a signature for the defendant. And if you could forward that back to the court as quickly as you can, because otherwise we cannot process the waiver.
Yes, Your Honor. And Mr. Anthony, I have your permission to sign the form to send it back to the court, right?
Yes, you have my permission.
Thank you. All right.
Okay, we're all set here. Thank you so much.
Thank you, Judge.
I think that completes the morning docket.
Mr. Anthony, you good?
All right, now, see you later, Mr. Humphries.
All right.
Okay, court will stand in recess until, oh, you're all set, ma'am.
Yeah, I'm gonna walk around.
Oh, okay. The court will stand in recess until 1:30.
Tammy? Hi. Hi there. I just wanted to make sure that it came back through.
Oh, okay.
Wow, you're really efficient there.
See,
I have it.
Everything is right here.
Okay, everyone, have a good lunch. We'll see y'all at 1:30.
Thank you,
Yes, sir.
Mr. Humphries.
Have a good
I
one.
received it.
Have a great,
Got
Mr. Humphries.
I have it. Thank you.
Thank you both. Have a great weekend.
Take care. Madam Court Reporter's here too. She says bye-bye.
Oh. Hi.
All right, take care.
Hi, Mr. Humphries.
Hi there.
Oh, there she is. Yeah.
Take me out.
Okay, so.
Right.
with the representation that's been made by your attorney, the matter that you would like to waive your right to an examination, do you understand that that would mean that the matter would automatically be bound over to the circuit court for further proceedings without the benefit of an exam? I need an audible, and, okay. And is that still what you wish to do? And so we're recording everything, and although I'm seeing you nod up and down, for anyone that's going to be speaking, you have to give audible answers because this young lady here is recording everything, so we have to be very concise about what we're saying here. Is that what you wish to do?
Yes.
Okay, are you doing so voluntarily?
No.
No? Are you being threatened or forced?
No. I'm doing it on my own.
You're doing it on your own? On your own accord?
Yes.
Okay. So with that being said, I do find your waiver to be knowingly and voluntarily given. The matter will be bound over to the circuit court as charged, which I believe it's just count 1, correct?
That's correct.
The AOI date is going to be August 20th. I will forward up to you the examination waiver form that needs to be executed by both defense counsel and the defendant. And we are all set. Is there anything further as it relates to Ms. Kimbrough?
No, Your Honor. No, Your Honor.
Okay, thank you. Any preliminary matters as it relates to Mr. Brown, to your matter?
Yes, Your Honor. At this time, the people are putting both the court and Mr. Brown on notice that the people intend on adding account of fleeing and eluding in the 3rd degree, account of resisting and obstructing a police officer, account of firearms, improper possession of a firearm in or upon a motor vehicle, as well as tampering with evidence.
Okay.
Well, it's very interesting.
Yes, Mr. Brown?
I said that was very interesting. I'll come over real quick, but I can't hear myself in the mouth. Okay, so.
It's kind of lengthy. Give me a second. I'm trying to flip through it. You just make a copy because I don't see it right offhand. There's a lot of paper here. Yeah.
I would like to make sure that I have all the discovery. And I talked to Ms. Bailey this morning.
Okay.
I talked to Ms. Bailey this afternoon. She assured me that I had all the discovery. I talked to the officer in charge, who I know, respect. And, but we were here on this very same case. We've been here, I don't know, any number of times. And I know people, the prosecutor, make any decision they want, they can exercise their discretion anywhere they want to. But it was not my thought, based upon our conversations, that we were even going to proceed with this case. That's just me, based upon the conversation I had. I think it's important because not only are we proceeding, but now we're adding charges. And that means to me that there must be something new to go from we may not proceed to now we want to add additional charges. Something had to happen.
Well, that's easy. Can we put a pin in that?
Yeah.
Is there something new?
Your Honor, I have not been in receipt of anything new. There is nothing new. And I never myself indicated that we might not be proceeding or anything of that matter.
Yeah,
I don't want to get caught in collateral issues. Is there any additional or any discovery that has yet to be tendered to Mr. Brown? It's kind of like very direct. Pardon?
No, ma'am. Everything that is in the people's possession has been turned over to Mr. Brown.
Okay, so there's nothing, there's no new evidence, nothing ever that made a difference in the decision to change 180 degrees from not proceeding to proceed.
Who told you that we weren't proceeding?
Now I asked you to ask me a question, I want you to answer my question.
No, there's nothing new.
Okay, that's good, thank you.
Okay, well, let me ask, are there any further preliminary matters?
Nothing further to the people.
Is there a motion for sequestration?
Yes.
Sequestration will be granted. Are you asking for an exception for your officer in charge? Or
yes, ma'am.
And your officer in charge, will put your name on the record, sir?
Sergeant Jameer McIntyre.
And is there any objection to Sergeant McIntyre remaining?
Not at all, Judge, not at all.
Pardon?
Not at all, thank you.
Okay, thank you. The Zoom gallery is currently restricted. The only parties inside of the Zoom gallery are those involved in this case or those working in the courtroom. And then The courtroom itself is restricted already because we're still exercising COVID restrictions, so there are no spectators inside the courtroom. And the third tier to sequestration is that this is live streaming on YouTube. So if there's anyone watching the live stream that shouldn't be watching because you're either a witness or a potential witness, now would be the time to stop watching these proceedings to maintain the integrity of this process. Please call your first witness.
Your Honor, just before we proceed, I just wanted to check, one of my coworkers indicated that YouTube was muted.
We've already remedied it.
Okay, just making sure. Your Honor, at this time, the people would call Officer William Teamer to the stand.
What are you doing, my good friend? Are you good? I mean, listen, you know what I mean? You know what I'm saying? Are you doing? You're so bad. You have a case in this? You don't have anything in court. Yes, you do. Oh.
Okay, Madam Prosecutor.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Could you please restate your name?
William Timmer,
And where are you employed?
Detroit Police Department, 8th Precinct,
How long have you been employed with the Detroit Police Department?
about a year and 8 months now.
Were you employed on March 6th, 2021?
Yes, ma'am.
Did you in fact work on that date?
Yes, ma'am.
Were you by yourself or with a partner?
With a partner,
What's your partner's name?
Michael Flannel.
I can do it. Michael.
Partner's name again?
Michael Flannel.
Flannel?
Flannel, yes.
Planning.
Flanning or flannel like a shirt?
Flannel, like a shirt.
Were you in full or modified uniform?
Full uniform.
Could you please describe what that looks like for the court?
So it's a full navy blue uniform. It's a badge on the front. Has Detroit Police on the left side of the shirt. That's about it.
Are you wearing your full uniform today?
Yes, ma'am.
Were you and your partner, were you on foot or in a scout car?
In the scout car,
Was the scout car fully marked or semi-marked?
fully marked.
Could you please describe what a fully marked scout car looks like?
So it's a white car. It has the Detroit Police logo on the side. It is multi-color with blue, red. Has lights at the top.
Officer, I'm gonna ask you, I should have said this at the beginning. We are challenged, right, because we have to wear these masks,
Yes, Your Honor.
and they have a tendency to muffle our voices. If I could trouble you to really try to speak very clearly and a little bit maybe louder, because Madam Court Reporter right there in front of you, she needs to take down every single word. And if you notice, she's kind of leaning in a little bit, trying to hear what you're saying. Maybe if that microphone even, it bends, it's malleable, you could, maybe if you could lower it down. There you go. Maybe a little bit. There you go. Thank you so much.
Officer, did you have occasion to go to 619 West Davison?
One more time?
619 West Davison?
I don't remember that address exactly.
Were you on West Davison?
I was went up in West Davidson.
What part of it?
Winthrop Street in West Davidson, cross street.
And is West Davison near Winthrop here in the city of Detroit,
Yes,
county of Wayne?
yes.
Why were you there?
So, it was a police chase that started in the 8th precinct and it ended at the intersection with the West Davidson and the 6th precinct.
Okay, where did it start?
It started at the intersection of St. Mary's and Midland.
St. Mary's and where?
Midland,
Midland?
yes, ma'am.
And what, while you were at St. Mary's in Midland, caught your attention, if anything?
So I observed the vehicle reverse into another vehicle and then to try to.
Repeat that, I'm sorry.
I observed a vehicle back into another vehicle and then the vehicle, that back end just pulled off. And so I went behind the vehicle to attempt to get a plate. And that's when somebody from the right rear passenger side fired multiple shots in our direction.
In your direction?
Yes, ma'am.
So, after observing the, what color was the vehicle that you observed back into another one?
It was black.
Do you know what kind of car?
I think it was a black Chevron.
Okay, so when you observed this black car back into another car, what, if anything, did you do next?
I instantly sped up to get behind the vehicle just to get a plate.
Did you attempt to make contact with that vehicle?
If I could, then I would have, but my initial response was to just get a plate and do a report and try to forward to the investigators.
Okay. So at any point, did you activate your lights and or sirens?
I didn't activate the lights until they fired shots in my direction.
Okay. So let's back up. So you were following a black car. How long would you say that you were following them until you started hearing shots?
I would say about 10 seconds.
And had the black vehicle stopped?
No,
Had your vehicle stopped?
no.
How many shots did you hear? Or how many shots did you hear?
I believe 6 to 7.
And where did you observe them coming from?
The right rear passenger side.
And what, if anything, happened next?
After that, that's when I hit my lights and sirens to try to identify ourselves more. And that's when we picked up speed. And that's when we ended up on the police chase.
Did the vehicle stop?
No.
How far would you say that you how far would you estimate you chased this black vehicle?
I would say the distance would be about 45 miles from St. Mary's and Midland all the way to West Davidson.
So during this chase, what, if anything, was occurring?
They was just disregarding red lights, and I was just trying to, stay behind them. There really wasn't too much going on. They didn't fire no more shots after that.
Did any of the shots hit you?
No,
Did any of the shots hit your vehicle?
no.
What if anything happened, when you got to West Davison near Winthrop?
When we got to West Davidson and Winthrop, they pulled up to a curve and they just stopped after that. And then, most of I would say about 3 people got out on the right side. And then I would say about 2 people ran west from that location. And then another one from the rear passenger side, the shooter ran east. So he ran around the car and ran east. And then somebody got out on the left rear passenger side. And then the driver got out the car. And then the driver reached back into the car. And then the driver got out, faced our direction. I fired 2 shots for officer safety. And then the driver just took off on foot. So they all ran the opposite directions.
Okay. How close to the vehicle were you when all of the people started getting out?
I would say I was about 40 to 30 feet back. Just for officer safety, because I know the gun was loud, so I knew it was a rifle. So I didn't want to be too close.
Okay. When these people were exiting the vehicle, were you able to get a clear view of any of their faces?
No.
What time of day was this?
I believe it started at 5:30 a.m. I'll say between 5 a.m. and 5:30 a.m. is when it started.
Okay. After all of the vehicle's occupants exited, what, if anything, did you do?
So once they exited, after I fired the 2 shots, me and my partner kind of ready to go.
Say good?
Once everybody exited the vehicle, me and my partner, we kind of just stood there for about 15 to 20 seconds to try to wait for backup. And then my partner pretty much just said, come on, let's get him, we can get him. So I took the scout car, we drove up closer to the car, and then we just chased him on foot after that. We was able to catch up to 2 of the females on the next street over, just from the location.
And after you caught up with these 2 females, what, if anything, did you do?
I handcuffed the first female, and my partner gave chase to another female that was further down the street. Once I handcuffed the first female, that's when back up came, and they pretty much held the female that I handcuffed, and then I was able to run down the street, catch up to my partner, and I believe they was able to apprehend, I believe, 2 more females.
Okay. Did you ever do any additional investigation around the area that the vehicle stopped?
No.
Was that the end of your involvement in this case?
Yes, ma'am.
I have no further questions at this time.
Cross-examination.
I'm sorry, guys. Okay, Officer Schumer.
Yes, sir.
My name's Mark Brown, representing Mr. Pitt over there. You didn't see him that night, right?
No, I don't recall this guy.
Okay. So you said the incident started at St. Mary's and Midland, right?
Yes, sir.
And at that point in time, you observed that some sort of a car hit another car.
Yes, sir.
And then pull off.
Yep.
And so you followed that car, right?
Yep.
And when you follow that car, you didn't follow him at excessive rate of speed. That's not part of the case, right?
No, it wasn't excessive.
So that car just.
It was what?
It wasn't excessive.
Okay, that car is just moving along, and then all of a sudden, was there you activated the lights? I'm sorry, no, back up. All of a sudden, did that car stop?
No.
Okay, so the car continued to move.
Yeah.
And then someone, fired out of the passenger side rear window.
Yes.
Is that, you're clear on that?
Yes.
Okay. And did you see a weapon?
No, I just saw a flash.
Okay. And you said you thought that there were 6 to 7 shots fired, right?
Yes.
All right. And were there shots from anywhere else on or about that vehicle other than the passenger side rear of that car?
No.
Okay. And just so I know, how close were you to it then?
I was about 30 to 40 feet back from it.
Okay, the distance from you to say the front door of this courtroom?
Yeah.
All right.
I can say that, yeah.
Okay. And you're on the driver's side, right?
Yes.
Because you're driving the car.
Yes.
And the car in front of you, is it directly in front of you?
Yes.
It is? So you're on the driver's side, that other person is on the right side of the car, right?
Yes.
You're on the left side of the car, right?
Yeah.
Okay. And you could see that shots were coming from the passenger side of the car, right?
Yes.
How do you know it wasn't coming from the front passenger side?
I could tell it was coming from the rear passenger
How?
side.
I understand. I said
He was
how?
pretty much hanging out the window. He was pretty much hanging out the window. I could see clear as day it was from the passenger side.
Okay, that wasn't this pitch.
I couldn't tell it was dark.
Yeah, okay. So a person hung out of the window and shot at you, right?
Yes.
All right. And then when that happened, did you turn the lights as soon as that happened? Or as soon as that happened, did you turn the lights?
Yes.
Okay. And so when you start the scout car, you look at the scout car video?
I never got a chance to.
Are you serious?
It never showed us.
Are you serious about, I mean, I'm not trying, are you serious that you never looked at the scout car video?
Asked and answered. He said
It
he
wasn't
didn't.
answered.
Objection overruled.
My question is, and I'm not trying to be sarcastic or anything. Are you serious that you never looked at the scout car video in this case?
It never showed us.
Okay.
It was pulled from investigations and then the radios.
Okay.
Wait, can you repeat that last statement?
The video was pulled from the communication center. They never showed us.
The us you're talking about is you and Officer Flannel?
Yes.
All right. So, so you wouldn't know exactly when it started anyway. Okay, so you go through, are you going through the neighborhood?
Yes. Yes.
Pretty high rates of speed?
Yes.
All right. And I'm gonna fast forward just a minute, I'll come back. You said something earlier about the driver got out of the car and then went back into the car. Did you say that?
Yes.
Was the driver a male or a female?
I couldn't tell at the time.
Well, you were much closer than you were when the shots were fired, right?
One more time.
When you saw that person get out of the car, you were closer to the car than when the shots were fired. Is that correct?
I believe so, but
Yeah.
I still couldn't get a good ID.
Okay, and that was on the same side as you, the driver's side, right?
Yes.
Yeah, and in fact, your car was a little bit further out in the street, and that car is closer, so you have an angle to look at that car, right?
Yes.
Okay, but you couldn't tell, although it was closer, whether it was a woman or a man.
I couldn't tell.
Did you later come across that person who got out of the driver's side?
I don't believe so.
Okay, so, all right. The chase goes on for 4 or 5 miles into the 6th precinct, right?
Yes.
All right. And once you get there on, which street is it? Winthrop in West Davidson.
Yes.
What's the biggest, closest cross street on Davidson there to Winthrop?
One more time.
What's the closest cross street to, is that by Schoolcraft?
Yes, it is.
Okay.
Schoolcraft is north.
Yeah, yeah. And are you, it's between Schoolcraft and Evergreen? No, Plymouth.
It would be, Plymouth is a little further down. It would be between Schoolcraft and West Davidson.
Okay. right, I see. So when you get to that point, it'd be fair to say that you get out of your car over the driver's door and fire, pop out, right?
Yes.
Right. You couldn't even see who was there. You couldn't see whether it was a man or a woman, right?
No, I couldn't tell what
Asked
was
and
the gender.
answered.
Objection sustained.
Move to strike.
I didn't ask him really. Yeah, okay. I'm sorry. I'm going to change my question. When you fired those two shots at whoever was getting out of the car, you could not tell whether you were firing at a man or a woman.
I couldn't tell the gender.
Okay. And you could tell the gender of the person who was firing out of the rear passenger seat in the initial encounter?
No, I couldn't.
Okay, all right. So, and you didn't see a weapon in the first instance, but in the second encounter, the final encounter, you never saw any weapons, did you?
At the driver that I shot at, yes.
Pardon me?
At the driver that I shot at, yes.
You saw a weapon with the driver had a weapon?
Yes, I seen when they reached back into the car, they came out, they turned in our direction. I seen them hold something about mid-level.
Okay. And you fired for your own safety, right?
My safety, my personal safety.
So you know, and how long has it been? 11 years?
What's wrong?
How long did you say you've been on the force?
A year and 8 months. At the time of the shooting, it was a year and 3 months.
Yes, I apologize. I thought you said 11 years. I couldn't hear it, so I apologize. But for sure, you did that because you thought that you were in danger.
Yes.
Okay, so that's justified. If somebody you think your life is being threatened, you fire, you would never say, I shouldn't have done that, right?
Right.
You did on the body cam, didn't you?
I did.
Objection, Your Honor. Hearsay.
Well, I'm not offering to prove the truth of the matter asserted. I'm just saying that's what you did, right?
Are you still, hold on.
Well, that is for the truth of the matter asserted, if he did say that then.
Not for the truth of this. That goes to his state of mind. And it goes to his credibility too, because if he says on the body cam, which he darn sure does, I shouldn't have fired those shots. I shouldn't have fired those shots. That says something about whether or not he was firing the shots for his safety, which is what this is about, credibility in addition to the facts, right?
Objection overruled.
You said that, right?
I did.
A number of times you kept saying, oh man, I shouldn't have fired those shots, did you?
I did.
Why? Because you didn't see any guns. Right?
I did. I did.
Okay. You didn't say on the body, never did you say on the body cam or anything, the person had a gun. You never said that, did you?
I didn't need to say that.
Now, I asked you what you need to say. I'm asking what you did say.
I did not say that.
Yeah, you did. So, and you would agree that even after the people jumped out, it's like a frenzy. A bunch of people jumping out of that car, right?
Mm-hmm. Yes, sir.
Yes?
Yes, sir.
He told me before I couldn't keep up. He said, the shooter ran around and ran east. Let me get my mind right. Where was this car? On what street was it actually on?
It was on the corner of the intersection of Winthrop and West Davidson.
Was it pointing towards Davidson or away from Davidson?
It was pointing towards Davidson.
Okay, so it was pointed westbound.
Yes. No, it was pointing south. It was on Winthrop just before the intersection of West Davidson, but it was still facing south.
Winthrop.
So we was facing the rear of their vehicle.
Mm-hmm.
Our vehicle was behind their vehicle. We was still looking at the back end of the vehicle.
Okay, so I'm trying to get it clear. I said, it wasn't actually on Davidson and Winthrop, right? Wasn't on those two streets, or was it?
It was on Winthrop and West Davidson. West Davidson across the street on the side street.
Okay. So the person who ran east, did they run away from the car or did they run around the car?
They ran behind the rear of the car and then ran east.
Okay, all right. I want to make sure. So the person who you talking about the driver or somebody else?
The person that ran east was the rear passenger, the shooter.
The rear passenger, right side?
Yes.
Okay, the rear passenger, right side, got out and ran around the car, around to the driver's side, and then on, right?
You ran around the car. the realty car.
Okay.
It just went east.
Okay, that's the first thing you see is that person jump out of the rear passenger seat and go around the back of the car and run across the street then, right?
The first thing I saw was everybody jump out.
But then you saw that person jump out and run and go to the east.
At the same time, pretty much as everybody else is.
Okay. And the vehicles, I'm sorry, I'm asking the same question, I apologize, Council and Judge. The car is facing south or north?
South.
Okay. So then, you saw the shooter run east. Okay, you saw the shooter run east. And you didn't get any return fire?
No, from him, no.
Pardon me?
No, from him, no. No, from no one, no.
Oh, okay, you said not from him, I thought maybe somebody else. So you ran, you immediately then ran after that shooter, didn't you?
Did I run after him immediately?
That's my question.
No.
Why not?
Because we were trying to keep a safe distance. We didn't want to approach too quickly.
No, just, and I'm correcting, I apologize, I don't mean to be disrespectful. I don't know we, I'm talking about you. You, so you were trying to keep a safe distance?
Yes.
So you got back into your car, is what you're telling me, you got back into your car and you drove forward to, towards the car?
Yes, after we waited for a couple seconds.
You waited for a couple seconds in your car, then you drove forward towards the car where everybody had left, right?
Yes.
They had all, it's 5 o'clock in the morning, it's dark, right? Yeah. And everybody's gone now. After you wait, then you drive up your car a little bit forward, right?
Yes.
You didn't drive right up to the car, did you?
Once everybody ran away, yes.
Oh, you drove right next to the car?
I drove behind the car. I got closer to the car once everybody ran away.
How far away were you?
I was pretty close to the car. I say within about 10 to 5 feet.
Like this is between me and you? Or
Yes.
closer?
Yes, about this. Yes.
About this between you and me?
Yeah.
So I count us about 15 feet. Council,
I'm sorry, what?
did you agree that's, are you listening to us? Are you said 15 feet between me and you?
I'd say closer to 20, 25.
Okay, that's fine, that's fine. So, so you wait a couple seconds, drive up between about 20 feet away from the car, and then you wait a few more seconds?
After that, my partner jumped out.
And where'd your partner go?
He ran west of the location, and I followed behind my partner.
He ran west?
He ran west of the location, and I followed my partner. And that's when he was able to apprehend one female.
Yeah, all the women got out and ran to the right, and that's where you ran, right? I said it just like it is. All the women got out of the car and ran to the right, and that's where you ran, right?
Not necessarily. We don't know who the driver is. The driver ran east.
Pardon me?
I said we don't know the gender of the driver.
Okay.
The driver ran east, and so the driver could be a male or female.
Okay, the driver is the person who went back into the car, and in fact, when you first testified, you indicated that you, for officer safety, once that person went back into the car, that's why you fired the shot, right?
Yes, once they faced our direction, I was able to see it going.
Okay. So
Wait, can you repeat that answer?
Once he was able to face, he or she was able to face our direction, I was able to see it going.
Ah.
And then thereafter, you ran away from the area where that person went.
I followed my partner.
I didn't ask you that. My question is very direct, very clear.
Hold on.
I'm sorry.
Okay.
You ran away from the direction of the person that you said had the weapon.
Your Honor, asked and answered. We've
I just-
established which direction this officer ran and which direction everyone else ran. It's been asked and answered.
I'm still a little unclear on it. I will be honest, so I'm going to overrule the objection.
I'm not trying to beat a dead horse. I'm just serious. So what I'm saying is, and I'm repeating myself now, not the question, but I'm repeating it. The officer testified that he saw the driver reach back into the car. I'm correct on that, right?
Yes.
Okay. And that caused you some alarm because you thought perhaps that person was reaching back in there for a weapon, right?
Yes.
Okay. And then that person runs to which way does that person run?
East.
East, right? And then when you got there, after waiting, what's the word? Possibly for a few seconds in your car and then driving forward in your car, then you go to the west.
Yes.
Right. And also, just so we're real clear, the person who you thought was the shooter, because you said that, right?
Yes.
The shooter ran ran east also with the driver, right?
Yes.
Okay. How many people got out of that car, you know?
I believe 5 to 6 people.
Okay, so we have 2 that we accounted for, the people with the driver who might have had a gun and the rear right seat passenger who you think did have a gun. The people with the gun ran to the east, and then that means either there's 3 or 4 other people who ran to the west, right?
Yes.
And so then you were there when apprehensions were made. How many people were apprehended of those people who ran to the west?
3.
Huh?
3.
3 what gender?
All females.
Was it apparent that they were female to you?
Yes.
Okay. All right. So, did you ever come to know who was the driver of the vehicle?
No.
Never.
No.
You don't know whether it's a man or woman, right?
No.
Okay. And so, may I have a smoke, Judge?
Yes.
I think it's no question I have this one.
Okay, any redirect?
No redirect, Your Honor.
Thank you. Officer, you may exit the courtroom. Any further witnesses?
Yes, Your Honor. At this time, the people would call Officer Michael Flannel.
Okay.
Excuse me, can I interrupt you?
Oh, absolutely. Bailey in here?
No.
I think we lost the prosecutor.
She was outside talking to somebody. I'm going to go look for her.
Did you print it?
I did, yeah.
I'm talking to another witness on the case there.
All right, sir, could you please state your name and spell your first and last name?
Michael Brown, first name is Michael, last name Brown, FLANDEL.
Just one L or two?
One L.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Here, that little half gate will swing open towards you. You have a seat. Madam Prosecutor, once he's settled, you may proceed.
Thank you, Your Honor.
Is it reflected in the courtroom? It is over on here. Sorry, yeah, we try to make everyone as comfortable as possible, but it almost looks like we're not on Zoom, but I know we are because of what I can see over here.
Yeah.
We're just gonna proceed on. It says we're still live, so. Oh, there we go. You fixed it. Your witness.
Could you please restate your name?
Michael Brown,
Where are you employed?
Detroit Police Department,
How long have you been employed with the Detroit Police Department?
since January 27, 2020.
Were you employed on March 6, 2021?
Yes,
Did you work that day?
yes,
Were you by yourself or with a partner?
partner,
What's your partner's name?
Officer Teamer.
Officer what?
Teamer,
Were you in full or modified uniform?
full uniform.
And could you describe that briefly for the court?
Can you say it one more time?
Could you describe what a full uniform looks like for the court?
Blue pants, blue shirt with a vest, gun and badge,
Were you on foot or in a scout car?
scout car,
Was the scout car fully marked or something else?
fully marked.
What does a fully marked scout car look like?
I had decoys on the side that says Detroit Police, lights and sirens on the top.
Did you have occasion
Officer
to?
Flannel, when you described what you were wearing, is it similar to what you have on right now?
Yes, exactly what I have right now.
Which not only is what you described, but there's also a stitched police badge on the front left of your shirt?
Yes.
Thank you. Madam Prosecutor?
Did you have occasion to be at West Davison near Winthrop on March 6, 2021?
Yes.
Why were you there?
Davison and Winthrop is when the vehicle came to a stop and 4 to 6 occupants exited the vehicle.
Is that the first time you interacted with that vehicle?
Yes.
Did your interaction with that vehicle begin at Winthrop and West Davison?
No, sorry.
Okay. So where did your interaction with that vehicle begin?
I would say Murray Hill in Midland.
And what, if anything, happened at, I said Mary Hill and Midland that attracted your attention?
We saw the vehicle back into a parked car.
I know it's tempting to use the word "we" because you've been working with a partner, but please make sure you testify only to what you did in the singular.
Well, I observed the vehicle back into a parked car.
And what, if anything, happened after that?
At that time, I observed the vehicle. Am I okay to look at my report, or?
Just try to do it from your memory, okay?
Okay, I observed the vehicle possibly going west on Midland. And then I believe the vehicle had went, south on St. Mary's. At that time, we tried to initiate a traffic stop with lights and sirens.
Okay, and so about how far from where you witnessed the car collision to when the lights were turned off, would you say, I'm sorry, not turned off, lights and siren were turned on, would you say you went?
Maybe a block and a half, maybe.
Were you in the driver's seat or the passenger seat?
Passenger seat.
What, if anything, happened after the lights and the sirens were initiated?
After the lights and siren initiated, someone from the passenger side of the vehicle leaned out the door window and started firing shots towards the scout car.
How far outside of the window were they leaning?
I would say half of the body or a quarter of the body looking out the window.
Could you see this person's face?
No.
Do you know if this person was male or female?
It appeared to be male.
Describe this person for me.
Because you could see a dark figure with, I would say somewhat like a short type of haircut. I couldn't really see his face, but the hair wasn't long or anything like that. I would say small forward, lower.
How long did this person hang outside of the vehicle?
I would say no more than 10 seconds, maybe.
How many shots were fired?
4 to 6 shots.
Were you in or out, inside of your scout car or outside of your scout car when the shots were fired?
I was inside.
Had either of the vehicles stopped moving?
Once we got to Davison, I went through this.
Before Davison and Winthrop, when the shots were happening?
Before no.
So after the shots, what, if anything, happened?
They continued down St. Mary's, then past Grand River, then all the way to Davison.
And what, if anything, happened when you arrived at Davison?
Once we got to Davison and went through the car appeared to hit the curb. That's when you see, like I said, about 4 to 6 occupants exit the car and took over and on foot.
Did you get a good look at any of these occupants?
Yes.
Do you see anyone in the courtroom here today that you saw exit that vehicle?
No.
Okay. How many people would you say exited the vehicle?
Yes. I think it's ask and answer. I think he said 4 to 6 already.
Okay.
There's no problem. You can ask it
Objection
again.
sustained if that's an objection. I recall hearing that as well.
could you tell who got out of the front, out of the front side of the, out of the front of the vehicle?
I observed just one male exit the front side of the vehicle, and I thought it was another male in the front driver's side of the vehicle.
Did you see any females?
Yes.
Could you tell where the females exited?
I know for sure 2 females exited from the rear passenger. I'm not sure of that.
When the people on the right side of the vehicle exited, could you see a gun?
No.
So after these 4 to 6 people exited the vehicle, what, if anything, did you see?
Just really everybody running. When the vehicle first came to a stop, it came to a stop twice. The first time, I believe the male had jumped out and then went a little further, and then that's when the driver and the rear passengers jumped out.
Do you know what the male looked like?
It was completely dark outside. And it was at a distance where I really couldn't get a facial.
How far away would you say you were?
I'd say about 100 feet.
I have no further questions.
Was it examination?
Yeah, I'm still copy of the report, but I can't find out how. Just
Yeah, just give me a second.
look at it in a second. I'm sorry, you have a copy of the report there?
Yes.
Yeah, this Judge Randall gives us
You were provided with one, weren't you?
Yes, Judge,
Oh,
but it's on the disc, and I couldn't find it right away.
Oh, I understand.
Okay, yeah, grab a copy of next one. Thank you, sir. Okay, just want to be clear. I'm gonna ask the same questions, but I'm trying not to ask over and over and over again, but the first encounter with this vehicle, at the first encounter with this vehicle on Midland or whatever it was, somebody leaned out of the back passenger side. Let's try it. Somebody leaned out of the passenger side of the vehicle and fired shots. Is that correct?
Not on Murray Hill, no. That's when I observed the vehicle,
okay.
back into the parked car.
Okay, where was it?
What was the accident?
No, sir. I'm trying to figure out, there were shots that were fired from that vehicle that you were following or chasing, right?
Okay, yes, that was on St. Mary's.
St. Mary's.
Yes.
Is St. Mary's in Midland, no?
St. Mary's and Midland cross each other. They're across the street.
Okay, so somewhere in that area?
Yes.
Okay, we're good, thank you. So, did you see the person firing? I think you said the person leaned all the way out?
Yes.
You thought it was probably a male? Yes.
Yes, sorry.
And, you said the person had a short haircut, like a fro or something?
Yes.
Okay. And, okay. Then let's proceed to the final stopping place. Now, you just said just a moment ago something, you said that the vehicle, as it was proceeding on, I don't know, was it on Winthrop or was it on Winthrop, made 2 stops, right? Is that in your report?
I don't know.
Pardon me?
No,
Okay. Why is it on your report?
because I'm remembering it now.
Okay, well, this happened in March, and you wrote down this report at the time of the incident, right?
Yes.
And certainly you were not, are you suggesting that the person who got out of the car, no. Was the person who got out of the car, strike that, I apologize for my being inarticulate. Did the person who got out on the first stop get out of the passenger side?
Passenger side, yes.
Okay. And that's the same side as the shooter, right?
Yes.
And that was a male, that's what you said?
Yes.
Okay, so that's, the shooter got out of the car before it came to a stop, right?
I'm not exactly sure that was the shooter that got out of the car, but it was another that got out of the car the first time.
I'm sorry.
I said, I'm not saying it was the shooter that got out of the car the first time, but it wasn't a male that got out of the car the first time.
Okay, got on the same side as where the shooter was shooting at.
Yes.
Yeah, okay. And you thought that wasn't significant to put that in your report when you initially wrote it back in March, right?
Yes, well, yes.
Pardon me?
You said I think it was supposed to be in the report?
Well, that's a good question. That's probably better than one I could come up with. Did you think it was supposed to be in the report?
Yes, but so the way it happened was the vehicle slowed down, kind of hit a curve, stalled a little bit. Somebody exited the vehicle kept going, and that's when it came to a complete stop.
Okay, now I'm gonna ask you a question I asked somebody else before. Did you ever see the body cam, the dash cam of this incident?
No.
Okay. And the dash cam was certainly on because your lights were activated, right?
Yes, once the lights are on, the dash cam's on.
Yeah. And so that dash cam would certainly show, well, pardon me, would it show, because it's clear you, would it show that, I don't want to ask you a question, I have a question. Okay, but you observed the car, did it strike a vehicle before the first person got out?
No.
Okay, so you saw a person get out of the vehicle, right? Is that right?
Yes.
Yes. Yes.
And that happened as your car was directly behind this vehicle, is that fair to say?
Yes.
Okay, and not very far behind it, maybe 50 feet?
More than 50 feet.
100 feet?
100, yeah, yes, sir.
Okay, all right. And when your lights are activated, there's also, did you have forward, like white lights or something you got? Oh, you got the headlights anyway, right?
Yes.
Okay, so that it was clear that this person got out of the car before all the other people got out of the car?
Yes.
Okay. And then when the car finally came to a stop, there was a pause, like 1 second, 2 seconds before people started getting out, right?
Mm-hmm.
Yes?
Yes.
Okay, I'm not bothering you, I'm not just trying to bother you, I'm saying yes because we have that on the
No, I
record.
understand, sir.
Okay, I apologize. Okay, so the person gets out of the car, one person, a male, you think, gets out of the car and runs, does he run, that would be west?
West towards, on Davidson.
On Davidson, he runs west on Davidson.
Yes.
Yes. That would be, what's that street? Oh, towards Evergreen. Towards Evergreen, right?
Towards Evergreen,
Yeah, okay. I'm so sorry. All right, so that person gets out, runs towards Evergreen, and then and now, did you see anyone, because you're in the car, you're not driving, but you're watching, you're ready to jump out, is that fair to say?
Yes.
Did you see anyone jump out of the passenger side and run around to the driver's side?
No.
That never happened, did it?
No.
Because it's clear, it's like the car is right in front of you, the lights are on, you can see everybody, right?
Yes.
Okay. Did you see at any point in time, anyone get out of that car with a weapon that was visible to you?
To me, no.
Okay. And, okay, on the second stop, then you said 46 people, so now we either have 5 or 4 people left after the first person gets out, right?
Yes.
Okay. So at the second stop, you said at least 2 people got out on the passenger side, is that what you said?
That I can see with my own eyes, yes.
Okay. 2 people get out, and that leaves us with either, I'm sorry, hang on that. That's really bad. 4 or 5. Either 2 or 3 people left in the car, right?
Yes.
Okay. And then how many people did you see get out of the driver's side?
Driver's side, 1.
1 person. So that leaves us with either one left in there or two left in there, right?
Yes.
Okay, but there were no people left in the car, right?
No.
Okay. So you observed a total of 5 people get out of the car, right? 3 got on the passenger side. How many you see on the driver's side? 1 or 2?
1 on the driver's side and 4 on the passenger side.
Okay, good. Maybe I just smoke.
Yes.
Thank you. Sorry, officer, just.
Pardon?
Can I turn my phone?
On or off? Off, yes, oh, yes. I thought you were asking for some water. It's behind you if you need it.
Thank you.
I'm just stepping outside and make observations.
Okay.
Judge, you read it? Absolutely. Thank you very much. I don't know, my last question is, but it was clear that you said that, 2 people got out, 3 people got out on the passenger side, right?
You said 3 people?
Yeah, that's what you said. Yeah, you said 1 got out first and 2 more females got out, right?
1 got out and then 4 got out. 1 got on the passenger side, 4 got on the passenger side, and 1 out of the front driver's seat.
Oh, I'm sorry, I misunderstood it. Okay, so the first person, somebody who looked like a male, jumped out of the passenger side of the vehicle and ran, that would be west. Yes. Right. And then the other person, then 2 females got out, 2 people that you thought were females got out of the back seat and ran west, right?
So that I could see out of the back seat, yes, but the total that was all running towards Davis and it was.
No, I'm not asking you, I'm asking what you already said, just so I make sure. What I heard you say before was 1 got out while the car was still moving, pretty much 2 stops. First stop, 1 guy gets out and run.
Yeah.
Second stop, then you said for sure there were 2 females that you said got out of the back seat. You said that, am I right or wrong?
Yeah.
Okay, and now you're telling me that actually 4 people got out the passenger side of the car, right?
Yes.
Okay, so that'd be those 3, there's 1 more. Where'd the other person come out?
Driver's side, front driver's side.
No. I'm only concerned
Oh,
with
the
the
passenger side?
Yes, sir.
Okay, so the first stop, it was one person what appears to be a male.
Okay.
The second stop was, and at this time, I'm outside the vehicle walking while the vehicle is still moving. I could see 2 females get out of the back. There was a total of 4 people running from the passenger side of the vehicle going towards Davis.
Oh, okay. So you only saw 3 people get out, but you saw 4 people running?
Yes.
All right. And the 4 people you saw running included the first stop guy, right?
Yes.
Okay. And then on the other side, you observed 1 person get out, and that was the driver, right?
Yes.
Okay. All right. Okay, so and then you just said something else. You said that when you got out, your car is still moving?
Yes.
All right. And so when your partner, teamer, did he fire shots after the first stop that the car made?
I would say the second stop.
Okay. So the first stop, your partner's still in the car, still driving, and then at some point in time, he had to sort of stop the vehicle for him to get out and stand on the side. You see, the vehicle still wasn't running when he was shooting, was it?
No, it wasn't.
Okay.
Oh, you said it was a vehicle running when he was shooting?
No, not running. Moving. I'm sorry. Thank you very much. Appreciate that.
Yes, it was.
It was moving?
Yes.
Okay. You were still in the vehicle when he was firing?
I was outside of the vehicle.
You were outside when he was firing?
Yes.
Okay. And did you see anybody run across the back of the vehicle?
From my point of view, no.
Well, I mean, you're right there. This is not like somebody, big angles or whatever.
Well,
Like
the way
you look at the street.
when I got out of the vehicle, I had cars on my side, I had some trees on my way on the side.
Yeah, I understand all that, but I'm talking about the back of the car. We're not talking about, this car wasn't parked on the curb, was it?
No.
Okay. You could see the back of that car, right? When you got out of the car, you could see it.
Yes.
And you didn't see anybody run across the back of that car, did you?
Objection, asked and answered.
Yeah, but that's in the context of him, I'm sorry. May I ask a question?
Well, the same question, because he did answer it. His answer was not from my vantage point.
Okay, that's fine. Thank you very much, sir. And then you proceeded to chase the people who went west, right?
Yes.
You and your partner chased the people who went west. You obviously, because you're on the passenger side, you're going the side you're on, right?
Yes.
Where'd your partner go?
From what I can remember, the same way as me.
Okay.
I didn't see him the same way. I just jumped. I just went to the west because that's where everybody was running to.
How many people were apprehended?
3.
3
females. 3 females.
3 females. Okay. All right. Oh, I'm sorry. Did anyone who got out of the car look like the shooter that you observed at St. Mary's and Midland area?
Did any of the shooters what again?
Well, I said, did anyone who got out of the car look like the shooter that you observed at St. Mary's in Midland, that area?
Well, once everybody got out of the car, it was kind of hard for me to see anybody's face or features.
I said, so can you answer, did they?
Wait, what was the question?
I said, can you answer, I was not speaking clearly. Did anyone getting out of the car look like the shooter? Either they did or they didn't?
No.
Okay, thank you. 1 second. All right. I don't think I have any further questions with this right now.
Any redirect? Madam Prosecutor, is there any redirect? Or are you thinking?
No redirect.
Thank you, Officer Flannel. You may exit the courtroom. Any further witnesses for the prosecution?
Yes, Your Honor, at this time, the people would be calling Haley Young to the stand.
Say young.
Yep,
Right, okay.
How many remaining witnesses do you have?
she'll be the last.
Approach.
Yes, sir.
Yes, sir.
Okay. Good afternoon. Could you please come forward? Maybe to the podium? Could you please state your name?
Haley Young.
One more time? What's your name?
Haley Young.
Okay, could you spell your first and last name?
You said spell it?
Yes.
Kayla.
And your last name?
YO.
Okay. And I noticed that you have someone with you. She's a newborn? So I have no problem with her continuing to hold and bringing the baby to the witness stand. I don't know if perhaps it's easier if we move a chair right here back in front like we had before. What would be more comfortable to you if you sat up here? She has a backpack on too. Okay, but then let's just try and find a chair since no one's offering any suggestions. And put it right up against this. If someone could point, let Sergeant McIntyre know where we used to have the chair. And then we'll just bring the microphone. Can you reach that?
Yes, ma'am.
We want to make sure that you are comfortable. Is there a little table still there or no? Well, I was wondering if we could maybe bring that little table back over like we used to have.
This, okay.
Leave that there though, just leave that on there.
I got you.
Okay. Before you sit down, I want you to be careful, but could you please try to raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth, the whole truth, and nothing but the truth? Yeah. Thank you. You have a seat. Okay, you're a witness.
Thank you, Your Honor. Could you please restate your name for the record? Could you please restate your name for the record? Kayla, do you remember March 6th, 2021?
No.
Do you remember where you were? Did you?
I didn't hear an audible answer.
No.
Okay. You don't remember where you were?
No.
Oh.
Do you remember speaking to police?
Yeah.
Do you remember speaking to police on that day?
I don't remember exactly when it was.
Do you remember speaking to them in March?
No. I don't know exactly when it was.
Do you remember speaking to police about a traffic stop that turned into a shooting?
Not really.
What was the answer?
Sorry?
Not really.
Thank you.
Did you provide police a statement about an incident involving a traffic stop that turned into a shooting?
I don't remember doing that.
I didn't hear her answer.
I don't remember.
Ms. Young, if you gave a statement, would looking at that statement refresh your recollection?
I'm not sure.
Can I talk to the attorneys really quickly?
Yes, ma'am.
Just
Yeah,
stand there.
Okay, ma'am? And I'm going to mirror what I just said off of the record to both prosecution and the defense. I don't know the case, the intimate details of the case. Prosecutor and the defense do. But I guess I'm really posing the question on the record to the prosecution and the defense as to whether or not it's appropriate that this witness have a court-appointed attorney.
I'm not aware, are there any agreements made with this witness?
No.
Okay, so I think she probably should have the option of having an attorney. She should be given the explanation about her rights and her right to have someone represent her interests here. I can't say that, but I think somebody needs to tell you that you have the option.
I didn't hear what did
She said, so you're saying I do need a lawyer? Yeah.
So I don't even. Oh, I'm posing the question to the prosecution and the defense, who are both intimate with the details of this case. For instance, I don't know what prosecution is offering her for, but in the event she was present in some capacity, I only want to pause to ask the question as to whether or not this issue was broached. If it was broached and determined not to be an issue, great. I think that record needs to be very transparent. I certainly don't want to trample on anyone's constitutional rights. So I will need input, because again, I'm going to reiterate that I don't know.
Your Honor, could we have another sidebar, please?
Yes.
having kids, you appreciate your parents more.
Hello, Miss Woodside. Sharon, what do you think for an afternoon?
Oh, Bailey, that's that. Could you see if Miss Bailey is in the hallway? She needs to find a way to communicate.
Mark is not.
Yes.
Hello, Miss Tammy.
Good afternoon. Are you here
How
for
are
my
you?
spot? I'm good.
For a witness?
Yes, we're getting, the prosecutor, so we can, hopefully she can use her phone or laptop and you can go in a breakout room.
Okay, can I talk to the prosecutor a minute?
Yeah, as soon as she comes back in, she's in the hallway. They went out to get her.
Okay.
Miss Woodside.
Miss Bailey, Miss
Yes, ma'am.
Woodside is here. She was gracious enough to assist with this appointment. Can you go into Zoom gallery? So she wants to talk with you first, and then she's going to talk to the young lady.
Is that my paramour I heard?
Yes.
That's what he said about you as well.
Hello, paramour.
Hello, Paramore.
She got a phone with her.
Yeah, but I'll do it on my phone.
She'll have to have the Zoom app and all that stuff on her phone though.
Well, she was ready to watch out in the hallway while we were like, no, you can't watch it right now. She's a witness. You know how to dial right into your courtroom, girl.
Oh, wow.
That's
Miss Woodside, I just sent you an invite.
He's back. Yeah, he's been back a little while, but yeah.
Miss Woodside?
I'm back.
Have you had an opportunity to chat with her?
I have.
Okay. Would she like to re-enter the courtroom?
She would not. I need to talk to Miss Bailey again for a minute.
Okay.
Please, Judge. Okay.
I'll go get my computer again. I'll be back.
Okay.
Or I can give you our telephone number.
I'm not driving, Judge. I'm actually in the line before you yell at me. I'm trying to get gas at Sam's Club with the 5,000 other people right now.
Oh, no. There must be some good prices there.
Well, just to keep us around, but you know, it's 5,000 people here.
This baby is. Well, hello.
Good.
Hello.
Hi.
Good, how are you?
I am here, thank you.
What you got for me?
No.
Have a good weekend.
Great.
I think I sent it. Do you see it, Miss Bailey? Miss Woodside?
Okay.
All right.
Cool.
But they just drawn, was drawn here.
Oh, I
in
see.
Last week.
Okay, so now we have Ms. Bailey back, Ms. Woodside is on Zoom. What is the posture of the prosecution at this time?
Your Honor, the people are not.
Oh, I'm so sorry. Could I trouble you to bring the Mr. Pitts out? Okay, we're back on the record in the matter of People versus Trent Pitts Jr. Madam Prosecutor, what is your posture at this time?
Your Honor, at this time, the people are not going to continue with the direct examination with Ms. Kayla Young. And as such, at this point, the people would close their proofs and ask that this case be dismissed without prejudice, as the people have not been able to meet their burden.
Okay, and I'm assuming you have no objection to that?
Yeah, I mean, I don't know, but if you have the exam, I understand that the people have not met the burden of proof during this exam. So I think it should be with prejudice.
Oh, no,
Yeah.
it would be without prejudice.
Well, if it's insufficient evidence, that would be the reason for the dismissal.
Yes.
Yeah, okay.
But would you want to
No, that's fine.
respond back to that and?
Your Honor, I don't believe that.
For instance, let's say there was an examination of home invasion matter that was presented, and there was 3 witnesses that were needed. 2 witnesses came, and the 3rd one didn't come. And they weren't able to establish, let's say, identity. It would be dismissed without prejudice, and if they're able to get their ducks in a row, they would be permitted to recharge, if you will, reissue. Oh, you can wait in the hallway, thank you. Oh, she needs the baby thing. And again, I don't want there to be any inference that I know what is or isn't there in the files that both the prosecution and defense are privy to. But unless there's an agreement between the prosecution and the defense for a dismissal with prejudice, it's going to be a dismissal without prejudice.
Thank you, Your Honor.
Okay.
But the basis is insufficient evidence.
And that is the basis that was stated on the record, that you had insufficient evidence to present today?
Yes, Your Honor, that the people are unable to meet their burden of proof for preliminary examination.
Now, I guess if we're talking about this, going a little deeper into the thought process, if your position, Madam Prosecutor, is that you have insufficient evidence, period, for which to move forward on these offenses, then I think it is appropriate to dismiss with prejudice, because there is no expectation or possibility that at some later point you might be able to garner a certain level of probable cause.
Your Honor, that is not the case. As Your Honor's very wonderful example of a home invasion, that would be the more accurate depiction of insufficiency of the evidence, that the people did not have a witness appear who indicated that she was going to be appearing. However, she did not appear.
Okay, with that being said, the matter is going to be dismissed without prejudice, which means, Mr. Pitts, it is possible that this matter can be reissued. Now, please make sure you have a conversation with your counsel, and he'll explain the fullness of that concept to you in greater detail. But as it stands right now, I am going to grant that motion made by the prosecution to dismiss. And I just need, Madam Prosecutor, your signature on this order of dismissal as you're the moving party.
Yes, ma'am.
And may I inquire who's the witness, Ms. Bailey?
Jasmine Sims.
Jasmine what, Sims?
Yes.
Okay, thank you very much.
Okay, we're all set here, thank you.
So, Your Honor, I'm also supposed to be here on the case that's being transferred, because I totally forgot.
Oh, what case is that?
That's a question on Delshawn Young that Mr. Mike sent the email about.
Not till Tuesday.
Oh, okay. I thought I was supposed to be here today. I was like, OMG, I think I forgot.
Yeah, no, not until Tuesday. I sent you
Tuesday,
an
okay.
email.
Okay, Tuesday will be fine. Very well. Everyone have a wonderful weekend. You and your staff, and stay safe.
You too, stay safe. Enjoy.
Okay, you too, Paramore. You know what, Paramore, you'll have to enlighten them about why we're Paramores.
He did. He already did.
Okay. And we share the same birthday.
He told us that too.
Yeah. Okay. Have a great day, all.
You too.
You see this